Good morning, gentlemen. Looks like today is April the 12th, the meeting of the Land Surveyors Board. Mr. Chairman, if you'd like to take it from there, we can. I'll just follow up suit.
Great. Thank you, Glenn. We'll start off with, as we're accustomed to, at the top of the agenda, we do have a statement I need to read first. The statement reads as follows. Notice of the April 12, 2018 meeting of the Board of Examiners for Land Surveyors was posted to the Board of Examiners for Land Surveyors website on April 5th, 2018. All right. With that being said, we'll go ahead and call this meeting to order. And first thing, I'm going to take a little liberty to welcome a new face here. It's been with some great anticipation that I wanted to welcome Mr. Jed McKeon to the board. He's our public member. I believe he's from Knoxville. Is that right? And
That's right.
Works as an attorney up there and all sorts of different practices. We certainly want to welcome him to the board and get accustomed to his face, and certainly look forward to your input and contributions to the board and the actions that we take here. Welcome aboard.
Thank you.
Thank you. Also with us today, a little bit different face. I don't know if you can see it on the camera, but we have Glenn working with us today. Normally Roxana is serving in her position, but she's on another board today, so we have Glenn filling in. I have no doubts and full confidence in your abilities today to keep me out of trouble. That's paramount.
I'm going to rely on some of the other board members for that.
Well, you're in trouble. And with that, also want to thank the staff for all their work that they've done in contributing to all the work that we've done in preface of this meeting and all the items on the agenda and all such. I know there's a lot of work that goes on behind the scenes, and certainly want to thank you guys for that beforehand. And Jamie, especially with your work on the applications that we try to keep up with. We're doing our best. Certainly lots of work going on here. Okay, with that, we'll go ahead and get started with items on the agenda. The first item we have is to adopt the agenda. I do want to request of the board the liberty to move some items around if we feel need, or we see the need while the meeting is going on, either just for meeting efficiency or with guests coming in and out. Just kind of hopefully you can accept some items moving around, not changing items, but perhaps we'll move some items. But that's subject to the board's approval of doing that. So I'll just take a voice vote. All in favor to do that, say aye.
Aye.
Any opposed? All right, thank you. We'll try to stick to the agenda as best we can, obviously. Okay, with that, is that a formal adoption of the agenda? All those in favor say aye.
Aye.
Any opposed? All right, easy enough. Okay, next item on the agenda, we do want to review and take a motion on the minutes from the January 25th meeting. I trust that you have a printout or on your iPad tablets a copy of those minutes, as do I. If I trust you've had an opportunity to review those minutes, if there's any changes, revisions, edits, anything to that nature, go ahead and bring those to our attention now. Otherwise, if everybody's comfortable with the minutes, I'll take a motion on those, please.
Make a motion that we approve.
Second.
All right, we have a motion and a second. Is there any further discussion on the minutes as printed? Hearing none, we'll take a voice vote on that motion. All those in favor say aye.
Aye.
Any opposed? All right, with that, the minutes from the January 25th meeting, 2018, are approved. All right. What do you got?
Jerry Carter's here for NCEES instead of Paul.
Okay, with that, I do want to take one brief second here and introduce a special guest we do have in our audience. I neglected to do so on the front end. I probably should have. Mr. Jerry Carter from NCEES is our guest today. Certainly want to welcome you here, sir. If there's not any objections, Mr. Carter, if you want to step forward to the podium there and just say a few words and introduce yourself, as we are live, I think we're being live streamed.
Yeah,
I
we're
believe we
live.
are. I think we're to that point these days, but certainly want to welcome you to Tennessee, to Nashville, to our board, our meetings that we hold quarterly.
Thank you. It's wonderful. I appreciate the opportunity. I will tell you, I'm not here alone. As we have Northeast Zone Vice President Paul Terrell, who's with me.
Great.
We had a wonderful breakfast, and we walked from the Omni, and as soon as we opened the door and saw the guard, Paul realized he did not have a photo ID. So he's in the process of retrieving his photo ID, and he'll be with us shortly. And he would like to then make a brief presentation in terms of NCEES, respond to questions, and just have an exchange. So we appreciate the opportunity to be on your agenda this morning, and appreciate being in Nashville. What a great place to be, particularly this kind of weather. So I'll wait until Paul returns.
Absolutely. You're more than welcome to. I trust that that the city is treating you well, but if you're looking for a pair of tickets to the Predators game, I think you're going to be out of luck.
I had heard. I had heard that. That's all right. Yeah, I think my wife has my schedule, and it doesn't include ice hockey games.
I understand that one. I understand that one. Welcome again. Okay. With that, looks like the first item we do have on here is the education report. Again, copies of the education report were forwarded to the board members here, plus you do have a copy on your iPad. There are a number of items here that have been submitted for approval of PDHs. North Carolina, Alabama, surveypdu.com, Nettleman, and Brad Tyson Thomas have submitted applications for CER numbers. I trust that you've had an opportunity to review those. If there's any questions on any of those, I'll take those now.
Mr. Chair, I did not receive that in email.
Okay.
And if you give me just a second to skim through it, I'll be caught up to speed.
Absolutely. Take your time.
I didn't receive those either, but I don't know
Okay.
if I was supposed to.
Yeah, go ahead and pan
got
through
it.
on your iPad there, Jackie, if you want to show them where it's at. Or one item I did want to bring to the board's attention for their approval. The first item I had a question on regarded the application from Nettleman Land Consultants. The course is entitled Texas RPLS Prep Course, requesting 8 PDH approvals. The contact person is Dr. Charles Nettleman. Obviously, sometimes the only information we're really given is the title of the topic of the course that's being requested approval on, this one being the Texas RPLS Prep course. And again, we're being asked to approve PDH courses as the Tennessee board.
I also, Mr. Chair, have a question on that, and I would like to make a general statement. Currently, Texas is the only jurisdictional board that's involved with NCEES that does not administer the PS examination. And the reason this gentleman teaches this particular course is because that's the way they examine their prospective licensees. Granted, this course may have some similar content to the PS examination, but primarily it's more, in my opinion, state-specific to Texas because of how they structure their exam for their licensees. I would have difficulty today approving that course without a detailed synopsis of the course to see how that it being presented as a Texas land surveyor prep course would benefit any licensee in the state of Tennessee that would want to attend and be able to claim those PDHs.
Mm-hmm. Mm-hmm. Jackie, what are your thoughts on it?
Well, I tend to agree with Tim. If we had a little more thorough description of what all was offered, it'd be better prepared to make a decision.
Okay, well, we do have the option here of requesting the materials from Dr. Nettleman
Yes, sir.
for our purview to review and then come up with, take a course of action with it there. Is that the course you'd like to take here?
I do have that upstairs.
You do have it with you?
Okay.
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 Maybe during one of the breaks we can get
I
an
was
opportunity to read
I was going to say,
Be
Mr.
good.
Chair, in order to get to this point, I think that at least our advisory board for our PDHs has reviewed something, and so chances are Ms. Jamie might have it.
I suspect if it's gone that path through the advisory board, it's gotten to the point here, I suspect it's probably something that will probably look favorably on Tennessee Surveyors, but I would like to get my eyes on it. Just the title of it alone just kind of makes me raise an eyebrow. So if we get a break sometime and get a copy of the materials, we can bring it back up on and vote.
Perhaps
for it
when we get in the legal report, Jamie, if you want to run up there and get it then, because then we have a period where covering some actionable items that won't require minutes at that time.
So have all of these been approved or reviewed by an advisory board to make
Yes.
sure they're, okay?
Yes.
Okay.
Yeah,
Perfect.
yeah, Jed, I think there's 3 members on the advisory
There
board, I
is.
believe, in which all applications for CER number approvals go to them first, independently. They review it and then see if there's a true value to the Tennessee surveyors. And then if they approve it, then it gets presented to us on this education report here. So it has been through the process to get to this point. So I feel pretty certain it's probably going to be favorable, but I still kind of question. I'd like to feel a little more comfortable with it personally. So if we get that opportunity, that'd be great. Okay, one other item I did have a question on I wanted to bring in front of the board was the item that was submitted by Brad Thomas. It was entitled Independence High School Surveying Math Presentation and was requesting 1.5 PDHs on that. I did reach out to Brad on this because I had a question about it. And I believe there may be a bit of confusion here. In that he's applying for a CER number, but what I think actually what he's applying for is his own personal PDHs as being the instructor of this course. In other words, his audience is students, not licensed professionals that are seeking PDHs. So
That's what he said when you reached out to him?
that was my understanding. It was an
Interesting.
email conversation back and forth. That was my interpretation of where he's going with it. So with that in mind, I tend to believe that there was just some twist or communication issues here and that he's looking for personal PDHs for the time that he spent in teaching the class, which is allowable under, Tim, what was the section there? Do you have it there with you?
It's under 0820-05-.04, 1, subparagraph E, and depending upon how he submitted that, Miss Jamie, our rule says that he can get the PDH value times 2 for teaching credit, but only one time. So in other words, that's why that I question the merit of a CER number, because a CER number allows the course to be taught multiple times, but if he's only teaching this course and he's teaching it to high schoolers, then he's only going to get credit for it one time, and the high schoolers are not getting credit for it at all. So I question that, and he should have submitted his time and effort and so forth relative to that. And also, it also speaks if he's a faculty member about teaching it, for example, like at Liscombe. I don't know that he is. But, I think we need to investigate that just a little bit more, and if you have some documentation, we certainly can look at that when we look at the other gentleman's situation, if that's all right, Glenn.
That sounds great. We can grab all of that once we hit the legal
Dennis had
report.
already submitted all this. When he left, we just put it on here, so I have the paperwork.
Good, thank you.
Yeah. And I suspect the same thing with the second application that Mr. Thomas submitted, the Lipscomb University Civil Survey class. I suspect that may be the same situation.
It is. Well, I would think so, too.
I would think so, yeah. So I'm going to get those two clarified, and we'll get some more information. We'll come back on that as well. But other than that, those are the only 2 questions I had on the education report. Was there anything else from the other members here?
Mr. Chair, is it your pleasure to table this until we review this additional information, or is it your pleasure to approve all the other items and then approve the 2 that we review separately later this afternoon?
Yeah, I'd like to get them all approved and review those other 2, actually 2 applicants, 3 items later this afternoon when we get that information.
Okay, so we'll table it for this point?
I'd like to get approval on the other
Okay,
items.
you want to approve the others? Okay.
Yes.
That's fine. Well, I'll make a motion that we approve the list as submitted, excluding the Brad Thomas 2 items and the Nettleman Land Surveying Consultant item,
Which we'll address later this afternoon.
which we'll address this afternoon. Yes, sir.
Excellent. All right, motion made. Is there a second?
Second.
All right. With that in mind, any further discussion? All right, by voice vote, all those in favor of the motion as stated, say aye.
Aye.
Any opposed? Excellent. Okay, Jamie, we'll look forward to later this afternoon, get a little more material. Hopefully we can cover that and address it later on. Thank you.
I do believe that we'll be able to cover probably all of our business before lunch. We've got kind of a narrow agenda today, primarily because we were trying to pack it all in so we could do our joint meeting at 1 o'clock. So I think we'll probably get it all, plow through all of it before then. I
hope so.
I believe so. We'll see.
I hope so.
Well, it's, I think it's somewhat dependent on what our NCEES representative's presentation, how long it lasts, and so forth. I think that's predicated on that. Because we want to certainly give them due time, because they've traveled a long ways, and we certainly are very interested in what they have to present to us and so forth.
Okay, I believe that addresses the education report for now. Next item on the agenda does move on to the legal report.
That is me. First of all, good morning. I'm Robin Ryan. I'm here in person as opposed to via telephone. And I just thought it would be interesting to tell you all that my dad was a chemical engineer. He just recently died at 95, but he also was a land surveyor. But not here in Tennessee, it was in Illinois.
Unusual combination there.
Yeah, it was. Yeah. And frankly, I went with him when I was a child when he did some surveying of mostly it was for developing neighborhoods. And I went with him a lot on those.
Probably got a little mud on your boots there, didn't you?
Yeah, I did.
That's good. That's
it was
good.
sort of cool. I could never figure out his instruments. It was like, what? Anyway, how would you like to proceed on the legal report? Would you like me just to read the numbers in, since you probably have had a chance to review them and then discuss, or do you want me to read the entire summation in? How would you like me to proceed?
Well, let's see. I'm probably not going to put yourself and all those who are watching through the laborious process of reading these word for word. So probably what we'll do, although it's still kind of awkward, is we'll take some time as a board to read through these personally, and then as questions come up, we'll address those with you.
Very well.
We'll do it that way. It's a little awkward. I know it does create some silence on the video, but it's just part of the process.
And let me just correct two things for you. In
Yes, ma'am.
number 2, that license has been renewed. It says it was expired to the grace. And in number 3, that license also has been renewed.
All those are valid licenses?
That's correct.
Thank you. Those were 2 and 3?
That's correct.
Thank you. That was one of my questions. And I believe we have 5 items in total, is that right?
It changed.
Yes.
3 to 5, yeah.
Yes. Two together.
Okay, I'm going to ask the members of the board here to address items 1. Take your time to read the summary here as provided.
Mr. Chair?
Yes, sir.
Can we ask Robin to read item 1,
Number?
yes, let's read the what I call boilerplate information into the record, and then I think we can gravitate to where you want to go, Mr. Chair.
All right. For number 1, the number is 2017-073-631. Would you care for me to read all of them or just one at a time?
Let's do one at a time.
Okay.
I don't even think there was a survey involved.
Well, see, this
Do any of you have questions about the first one? And let me just tell you that this respondent never filed a response, which is troublesome.
That's my
what we were
question.
just talking about.
And we sent what's called the last chance letter, giving the respondent an opportunity to file a response, and there was no response filed.
Those sent registered mail, do we know that they received them?
I know they received. Can you open that one? It is Humphrey. Mailed on December 14th.
They sent it via email.
One on December 14th. Go back to the others, okay? Also, the initial letter was sent here.
It was initial letter.
Yeah, the initial letter was also sent via email on November 14th and sent regular mail, I believe. Is that regular mail?
Mm-hmm.
A regular mail. Can you open that up, please?
Mm-hmm.
And the regular mail was also sent November 14th. And as far as we know, we don't have any returned mail in the file saying that the address was not applicable.
Okay. Is there any policy of any kind that we have in terms of sending out registered mail so we can verify that they received it?
I don't. Go ahead.
I don't believe this commission has a requirement that it be sent certified.
But I will be honest with you, even in those programs where we do have registered or certified and regular mail, we send them both because then when the certified isn't delivered and the regular mail doesn't come back, we know there was a delivery of sort. And regular mail does come back to us if the address is no good. Plus, the emails did not come back. So that's very sort of troublesome. I don't know if there's something wrong. I don't know.
Well, I'm just trying to avoid the window of, if we were questioning the respondent, that, I didn't get the email
You're
or
right.
I didn't get the,
I agree.
Generally speaking, registered mail takes care of that problem.
It can, indeed.
And when we're dealing with a situation like this, it's a little more comforting, I think, to know that they received the issues that are going on here.
It is the initial complaints are sent out by the what is that? Centralized complaints, and they follow the laws of the various programs as far as how things are sent out. But
Were the emails sent with a read receipt?
I can't tell from the information in the file.
I'm going to ask the question.
All right.
Can we have the respondent come to the board meeting so we can address him directly?
I don't think so.
No.
Refer to Sarah on that.
Can't do that?
No.
Okay. All right.
Well,
Goes to formal hearing, then we're.
Yes, that's a formal
Then you do
hearing
it,
is when
yeah.
you do
That's
it.
the
yeah, but that's
different.
That's him
Understand?
pushing it to there.
I'm
Yeah,
I'm trying to give him an opportunity is what I'm trying to do.
In the past, we have done it in situations where we have multiple occurrences of discipline where we have a conference with that individual, but it's only with one board member meeting with them,
Right.
trying to
See,
figure out what's going on.
We used to do informals, because
Yeah.
I've done several of those in my tenure on the board, of folks coming in, So, anyway, let me start, Mr. Chairman, if I can. Sure. I think there's two violations here, as it is written. One violation deals with 0820-4-.04, which is public statements. It's my opinion that if a registered professional, in this case the respondent, had indicated to his client, in this case the complainant, that he had done something and he failed to do that, then I think that he is violated that particular statute or rule. Secondly, I have real heartburn over the fact that he has not responded whatsoever to this matter, and that's a violation of 0820-4-.02, no, I'm sorry, 0820-1-.06 1K. Anytime the board asks you to do anything, and as far as I'm concerned, if it's via the complaint process from the attorney staff, then if you don't respond, I think you've violated that. So I see two problems with it. The first one, members may not quite agree with me on that one, but the second one, I think, in my mind, is pretty clear. I will ask Ms. Robin if, was this the recommendation from the case reviewer, or is this the attorney recommendation?
This is the attorney recommendation,
Okay.
and this is the law. Now, the rules that you just suggested would then probably fall under misconduct under the law I had referred to.
And I'll make this statement, I do not like our penalty section. I've made this statement many times before in board meetings. It's kind of a catch-all. It grabs a lot of things. It's not as definitive as maybe it could be, but I know we're hamstrung by our legislature of how to manage some of those things. So I'll move forward, and I just made my comment.
Can you give me those statute numbers again, please?
Yes, sir.
These are the rules.
Rules, I'm sorry.
Oh, okay.
I get rules and statutes mixed up.
Right.
And I apologize because I don't have a legal mind. Mine's mainly illegal.
Lucky you.
0820-4-.04 and 0820-1-.06, 1, subparagraph K. We can also reach out in looking at it to 0820-4-.02, section 3. So there's several things that we could reach out to get to on this,
I think there's a problem with the citing the second one in K, because what the rule says, it's a violation of a board order, and this is not a board order.
Well,
This is just a complaint.
Well, we can also go back to, let me see if I can find it. In professional conduct, it stipulates, if I remember correctly, and you certainly can correct me, that it's the registrant's responsibility to respond to all board communications. Right here. It's 0820-04-.02, paragraph 3 that I cited last in the rules. It says the registrant shall respond to all inquiries and correspondence from the board within 15 days of receipt and shall timely and deliver, da-da-da.
I think that one's appropriate. You can
Okay, that's the one that I cited last.
Yes,
Because, I mean, I understand about the board order because we
Yeah.
technically have not ordered them
That's
to
right.
do anything.
Right.
But at the same token, under the rules of professional conduct, they did not respond. And I have a problem with that. You know, I mean, if I'm caught on the carpet, I'm at least going to say something. I'm going to ask a question. I'm going to do something. But when I do nothing, then, you know, that's not good. I'll just leave it at that.
I don't disagree, and again, that would also fall under, I believe, the broad section of the law we're talking about that make it's just not a rule violation. You have to apply it again to the violations of law, and I do think that would fall under misconduct, under your violations.
Now, my question for you, Ms. Robin, is this. Having previously stated what I said about our penalty structure, do the sections that I'm citing, or the rules that I'm citing, do they fall in different categories from a standpoint of penalty? I think they do, but that's me.
Well, in 120A has a violation up to $1,000, and then 120B would have a violation of up to $1,000. So if you had a violation A and a violation of B, it could be up to $2,000.
Right, and that's where I'm going, because
Yeah.
that's going to be my recommendation.
$2,000.
Yes, ma'am. My recommendation, Mr. Chair, if we're to that point, unless we want to have further discussion.
The rule number that you're referring to in regard to the lack of response by the respondent.
It's in professional conduct, 0820, 04-.02, paragraph 3. That's in the new rules of conduct we just approved
Yep.
not too long ago.
All right. Having read that, let me ask legal here. Having read that rule there, it's pretty clear. Is legal comfortable with the attempts of communicating with the respondent
Yes.
in terms of the prior emails and regular mail?
Yes. I'm comfortable with what was sent.
Okay. And we're positive that we have not received any kind of response.
There is nothing in the file that shows that there, A, was a response received, and B, that anything is returned to us.
Okay.
Mail attempts or the regular mail attempts. Again, unfortunately, I don't have control or any of that. I just have what's in the file, but we're pretty good about putting in And if something was returned, she would have
would
gotten a
send it to
copy of it,
Right.
and it would be in the file.
Right, and again, those dates, the original email and regular mail were November 14th, and then a follow-up email on December 14th. And here we are in April, and still nothing. Okay, so I
Having
think
said
we've
that-
well past the 15 days.
It is indeed. And having said that, should a response then come back as a result of a consent order sent and can show that somehow there was communication that somehow didn't get to us, I will bring it back to you for your review.
I need.
Ready for a motion then, Mr. Chair?
Unless there's other discussion? Okay.
No, I mean, I think since the respondent has not responded, we have to take the information provided by the complaint as fact.
Yes.
And, one, he had even though it may have been verbal, he had a contract. The respondent promised to assist. He paid him for it, and he didn't provide the service. So that's, I'm not sure which rule or which statute it falls under, but
I think we've got the
it's under
rules. I think we have the rules
professional
right, I
conduct, too,
believe.
I think, so.
Yeah. I think Ms. Robbins is comfortable with the rules we've cited.
I'll tell you, in my opinion, in what's contained in the summary, the issues there between the complainant and the respondent are not really where I have a problem. The problem that I have settles down with where the respondent has never had a response back to the board. That's where my issue is. It's not between the two parties separate. Is that the way you see it as well?
I don't totally
Or
agree
do you
with
see
that.
it other than that?
Well, I lean with where Jackie's going from the standpoint of I think that be it a verbal contract or a written contract, we don't know which.
Right.
I don't think the respondent performed because it would be very simple for the complainant to go to the local registrar's office and see if their plat had been recorded, and if that was what the agreement was, and it was not, then that kind of answers it. Clearly, I can say, Mr. Chair, that there is a little bit of gray area there, but I think Mr. Dillahay aptly stated it. When we don't have a response, it kind of puts us on one side of the matter.
Might I suggest that you might be the most comfortable because you don't know the other side of the matter, but it's enough to raise the issues, that you can still call it misconduct for failing to respond within 15 days and limit your civil penalty to $1,000, because that way it's very clear that the issue is we don't know what happened. You can always get a response later on, and if it turns out there's more or different, you can always open another complaint at some point.
I'm not a fan of secondary complaints.
I would say chances are when Robin sends a consent order for $1,000, they're going to respond.
I agree with
guarantee
that. I agree with
So,
that.
in that spirit, Miss Sarah, my notion is that, and the motion I'm going to make is that it be $2,000, because
Separate violations, one for not responding
Right.
and one for,
Yes.
okay.
yes, ma'am.
Do we have an agreement that it's 2 violations, though? I don't
Amongst
know.
us,
Yeah,
I mean.
amongst us.
Well, where do you stand? You haven't said. Mr. New Guy, throw your hat in the ring.
I don't know enough about these rules that you guys are flipping pages on to know, but if our concern is the response, I agree. This person's ignoring it and thinking it's going to go away, and it's obviously not, and we're going to get a response once you send them, hey, you owe us X number of dollars.
Right.
So I don't know that it matters, because we're going to get him and we can quiz him at that point, regardless.
Well,
Because he's going to seek relief.
Right. I like what Ms. Robbins said, when we send it, we'll see where it's at, and we get a response, then we can, I would rather, let me, Jed, I'm the bad guy on the board, okay? So, I'm the guy that's always dropping the hammer, except when Jay hits me with it. I would rather give the stiffest penalty in a situation like this because of vague information, per se, in this scenario, and the respondent come back and Ms. Robin bring it back to us and say, okay, board, here's the response, here's where we're at, we need to modify the consent order or whatever.
Well, let me just explain. I wouldn't bring it back just because a response was filed.
Oh, okay.
Because the issue would be right now is there is no response file, and that's what we're citing him for. I would bring it back if the respondent said, I did send a response, or I never got the letter. Then the entire thing could be reviewed again.
Oh, okay.
And let me explain the process so you understand. I sent by the way, a consent order is different than you probably are aware of, okay? So don't think of it as an order. It's really a contractual type thing. And I have to say that because lawyers think differently.
Really?
Yeah. We send a consent order. The respondent has so many days to answer the consent order by signing it and sending the money in. If they choose not to do that, then it goes into litigation. And then the litigation would be, and I haven't looked to see what you all have agreed and allowed to be before an ALJ alone before you all, but then it goes before either an ALJ, administrative law judge, and all of you as acting as a jury, or it goes before an ALJ alone. So it won't be represented to you unless I get information saying, yes, I did respond, or no, I never got it. And if there's proof of that, then I bring it back to you together with the response. It's fine.
See, now that's something that, and I appreciate your explanation, but that's something that I don't like from the standpoint of the fact that what we're doing here is live, and if I'm the respondent and I'm sitting home on my computer right now, and I heard you just say, if I send in a letter that says, no, I never got it.
But have to have
that
proof.
Yeah.
I mean, I'm not.
You know what I'm saying? I feel like we're telling the respondent
No.
what to do,
Let me just
and we
explain
haven't
it.
even acted. No disrespect.
No, it's okay. I'm not a pushover. You can ask anybody over here. I'm one of those aggressive people, and you'd have to have more than just a statement saying I never got it. Okay.
Okay.
So there would have to be
Fair
a
enough.
long line, or like I was in the hospital for 6 months, or something
Okay.
like that. If there was sufficient information given to me that I believe warranted, bring it back to you as an explanation of why there was no response. I would. Otherwise,
Okay.
it wouldn't come back.
Okay.
So, and I like the concerns here that service is paramount, because it's important that we know that this person has noticed that we're saying things about them behind their back,
Right.
essentially. And so if that's the case and we take these facts on their face, I think we have the ability, and we're going to make a decision to either rule $1,000 or $2,000. I think that's the question at this point. Is there enough in these facts, and I don't know, that other than, all right, so the bottom line render is worth $1,000. Is all the sentences above the bottom line worth another $1,000? What do you guys say to that?
My notion is yes. Jay?
I'm still sticking with the one.
Okay.
I think there's been two violations. I tend to agree with Tim on this one.
All right, the floor is open for a motion if there's one to be made.
Okay. We'll give it a shot. We'll run up the poll here. I'll make a motion that it be a $2,000 civil penalty with the appropriate consent order, et cetera.
2 violations.
2 violations, yes, ma'am.
Could you state the rules? Just for the motion.
The rules
specific
for the
rules.
motion are 0820-4-.04 and 0820-4-.02, 3.
So 3. Okay, very good. All right, the motion has been made. Is there a second?
I second.
All right, any further discussion on the motion and second? All right, hearing none by voice vote, all those in favor of the motion say aye.
Aye.
Any opposed, say no. No.
I'm going to abstain. I don't know enough yet. I'm sorry.
Guess which one's the lawyer?
All right, so we do have 2 yays, we have a no, and we have an abstention.
Which means it passes.
Which means it passes. I think. It does. It passes. Okay. All right. With that being said, motion made, seconded, and approved. We'll move on to item number 2. Robin, if you'd introduce number 2 for us, and then we'll take some time to read through it.
Thank you. 2017-077681.
Ask the members of the board here to take their time and read through the summary, please. Okay. We had adequate time to review?
Yes, sir.
All right. Any thoughts?
Is there a duty to non-compete or something, or to be hired by okay. That was my only question.
Mr. Chair, my review of this particular case tells me that it's basically a huge communication issue. However, from the standpoint of the registrant, I think that, we have a rule 0820-4-.05 that speaks to conflict of interest, and the narrative that we were provided does not directly clarify in my mind of how the respondent definitively dealt with the parties here. And the only thing I'm saying is I do not sense a violation. However, I sense one of our many multiple letters, which I never know which one is applicable. I think we have a letter of instruction, I think, which is the kindest, gentlest slap on the hand. It's my notion, Mr. Chairman, that this kind of deserves a letter of instruction relative to that particular rule that I stipulated, just as for anything else, as a courtesy from our board to the registrant, or the respondent in this case, to let them know that, hey, you might ought to kind of pay attention to this, and maybe the next time you might handle it a little bit different, because it appears that the licensee has only been licensed just a few years. So it's just kind of I think that's a courtesy from the board more than being chastising them.
Yeah, I would tend to agree with you. I don't really see a straight up infraction of any of the rules, but I do think maybe might be a little lesson in business practice, perhaps, that was learned here by the registrant. It can be confusing when you're dealing with adjoining neighbors and surveying properties and having to deal with both neighbors, and it is kind of a lesson learned through experience and time. And like you said, he is a young registrant. I don't know his age, but obviously by registration he's young.
He's been practicing 14 years.
14? Okay.
Yeah.
So it happens. But yeah, I would tend to agree that a letter of instruction, I think, would be a good idea. Again, I don't think this is worth any type of penalty or rules violation of any kind, but rather just a little guidance and to kind of watch yourself. Jackie, what do you got?
As made.
All right.
What can you articulate a little more what's in this letter?
Robin?
It says that a complaint was filed and that these were the issues discussed and that the board or commission has reviewed it, this is true for all of them, and suggests that it might be beneficial if you review the rule or law in question concerning, in this case, potential conflicts of interest in matters. It doesn't go on the licensee's record as any kind of disciplinary, but it does raise, let's just say we get a complaint a year from now on the same kind of thing. It is something they didn't pay attention.
That's a letter of instruction.
Instruction.
And we have about 5 different categories.
Yeah,
I
you
think.
do. There's also
All the
letters
way
of
up to a
warning.
letter of reprimand.
Yeah.
Or,
Okay.
But it does not go on the licensee's record as a disciplinary action.
I think that's important. That is not what we're trying to do here,
Right.
I think.
I don't love. I mean, I think these neighbors just hate each other more than anything else. I don't think it's this guy.
All right, with that being said, Jackie, I think you said your part. Is there a motion to be made on this?
I make a motion that staff provide a letter of instruction relative to 0820-4-.05 to the respondent.
Excellent. Motion on the floor. Is there a second?
I'll second.
Okay. Motion and a second. Further discussion? If any, hearing none by voice vote. All those in favor of the motion as stated, say aye.
Aye.
Aye. Any opposed, say nay.
Nay.
All right, we have 3 ayes and 1 nay. Motion passes. All right, Robin, if you would introduce item number 3 for us, please.
So indeed, 2018-002171. long one.
The board would take a minute here to review.
Oops, sorry.
Okay. Trust everybody's had an opportunity here to review. Okay. Based on my reading of the summary here, it's pretty involved. Mainly deals with, it looks like a survey being conducted on a property, and that the respondent / surveyor or his authorized field crew had driven a vehicle and with their equipment and themselves across the adjoining property in the performance of the boundary survey of their client. It looks like the owner of that adjoining property didn't take too kindly to it. They exchanged a few words back and forth and ultimately filed a complaint about the process. My opinion, reading through it, if there was any damages that were done where the crew had gone across or anything like that, but I'm not seeing that in the summary here.
There
so
wasn't.
I
This
can't
was
go
just
that
a
way.
very contested
That's what it sounds like.
situation based on the initial parked in the wrong spot, to
Right.
which the crew apologized and moved,
Right.
but that wasn't acceptable to the people owning the property.
See that, yeah.
It's remote
Apparently it
area
expanded, yeah.
Yeah,
A few
and-
heated words and things like that, I
Yeah.
get that.
and threats.
The respondent did state and cite TCA 6218-124 dealing with surveyors being able to access adjoining properties in the performance of a survey with not only themselves but their equipment and their vehicles. So there is some precedent there in terms of a TCA code, in terms of what the respondent is referring to. And in my reading of it, I tend to agree with the way he stated it there. Again, it just seems to me, in my opinion, that it's just a neighbor who didn't like it, and they exchanged a few words, and looked like a telephone call went across and said a few things, and it just kind of went from there, and by golly, I'm going to file a complaint.
I don't disagree with that at all.
Anybody see it any differently? Tim or Jackie? Jed, anything there?
Just as a comment, as written, it bodes, in my mind, for a civil action by the complainant if they so saw fit. Now, the question, Ms. Robin, is this: if the complainant would file a civil action and get judgment from a competent court relative to that,
Or what?
for damages that the respondent may have caused.
Okay, if there were damages
If
done,
there were
yeah.
damages, if there were damages, then in order for us to be able to look at this, we would have to, how is it, dismissed with prejudice?
With us, that
Yeah.
would be, if at that point they chose to refile a new complaint based on the court action, they could refile a new complaint based on the court action, which we could then review, saying that other facts were revealed, and this is what happened, and the court found that these respondents not trespassed, but destroyed property, and then you could review that particular issue
Right.
if it was brought before you.
Well, I guess my question is,
It would be a new complaint.
It would have to be a new complaint?
Yes.
Because in the past, previous young ladies that sit in your all's position that were in the attorney staff indicated that we could dismiss in a certain manner such that if new evidence was determined, that we would be able to address it without a new complaint.
If there was already a case pending in circuit court, you could
Right.
do what's called a litigation monitoring order, but there is
Okay.
not.
Okay.
So basically, what you would have is a brand-new complaint.
Okay.
Because if, as you suggested, this went to court and a court found there was a violation by this respondent in some way, then that would be a brand-new complaint, and the complaint could be filed, and you could review it at that point. If there was a pending court matter, you could do litigation monitoring, but there is not. Yep.
Chairman, I make a motion that we accept the recommendation from our legal staff and dismiss
I'll
the
second that.
complaint.
Okay, we have a motion and a second for dismissal. Is there any further follow-up on that? All right, hearing none by voice vote. All those in favor of the motion as stated, say aye.
Aye.
Any opposed? All right, motion passes. All right, I do want to keep in mind that we do have our special guests out there in the audience. I do want to get you to the podium. I know you're anxious, but we've got two more items we want to cover. I think we can do it quickly, and then we'll address you all, okay? I appreciate your patience. All right, we'll move on to item number 4. Robin, if you'd introduce that, please.
Sure, and number 4 and 5 are related to each other, just to tell you that in advance. Number 4 is 2018-002331.
Order, take a moment to read through item number 4, please. Yep. You good?
Anytime you are.
Okay. Y'all good? All right. In reference to item number 4, looks like we got a lot of things going on here. And it does give reference to item 5, I believe. Is that right? Is that the way
That's
I'm reading
correct.
that? When it states the respondent below, is that referring to
That's
below being
correct.
number 5?
So the complaint was initially opened against respondent number 5, who was not a licensee, but respondent number 4 is the licensee that was handling the matter.
What I can get out of this, it kind of looks to me, kind of jumps around. Maybe there's 2 or 3 different things going on here. The gist of what I'm seeing is essentially the complaint is upset that his plat was deferred an additional month from the November to the December meeting. Perhaps there was a meeting in there they thought was a planning commission meeting, but in fact was I think it was a DRC meeting, I think it was. BZA meeting. And then we start jumping into, there's some issues about a particular pin in the ground and a location in relation to a driveway, but it looks like that got resolved there at the end. So I'm not seeing, anything in the complaint directly related to our authorities here, unless I'm missing something. Jackie or
I agree with you.
Tim, Jed, you see anything? The recommendation from staff was to dismiss.
Well, are we going to talk about 4 first, or are we going to talk about 4 and 5 together?
Good question.
Well,
But because they are still interrelated,
they
because
are.
I do have a problem.
Okay, let me explain the dynamics of it. 4 is the person who did and was hired to do the survey. Number 5 was the person working with the group that suggested number 4 to do the survey. Number 5 had nothing to do with the survey at all.
I disagree with what you just said.
Well, but that is what happened.
By your narrative, it says something different. It says, and I shall quote, it says respondent, which is number 4. I'm gonna say number 4 and number 5 for me. Number 4 told complainant that number 4 had agreed to help number 5, and that number 4 was a licensed surveyor. Okay? Now, if I misstate, you correct me. Number 4 states that number 4 was not involved in the initial meetings between the owner, real estate agent, and number 5 when they attempted to work out details on how to divide and cost.
Yes, and that was the initial meeting when they were into divide and cost, and maybe I should have used words that might have been more understanding. The initial meeting was, and as I read all of it, is here's a piece of property. We're going to have to get them divided up. How do we get them divided up? We have to find appraisals to do it. And do we have any idea what the costs might be? It was like a meeting of the people involved in the property, not a meeting of deciding how to divide the property, not a meeting of deciding anything that I think, for reading it, would deal with appraisals. It's more of like a plan on how to get the things done. That's how number 5 was involved. And number 5 apparently knew number 4, and that's why everything was referred to number 4 when it came down to doing the actual work.
Well, the problem I have with it, that meeting, number 5 was there as a surveyor, and he was representing himself as a surveyor.
No, that is not true.
Saying that.
And also you should understand, and you should know that you can probably read it further, that the complainant then came back and said, "Hey, everything's fine. I'm withdrawing all of it." That doesn't affect you. But my point,
I don't have an issue of the complainant wanting to dismiss the ultimate work product of number 4. I don't have an issue with that. I'm trying to establish the relationship between number 4 and number 5.
number 5 was a former.
And number 5's relationship with the complainant.
Okay, number 5 had no relationship with the complainant, except for the complainant was involved in the property owning in the first place, okay? Number 5 was a part of the committee, a part of the group that looked at the entire matter. Number 5 had nothing to do with the survey at all, but number 5 is a former licensee, knew this survey and knew what was needed to be done, and recommended a professional to get it done. There was nothing else in this file showed anything else. Now, and the reason that the complaint was open against number 5 is because the complainant didn't know the actual person doing the survey and made the assumption and knew that this person was not a surveyor. This person did not represent themselves as a survey at all in any of the documents I have.
The narrative could have been structured a little different.
Well, I'm not
from my reading.
Okay, well, I'm not sure what.
That's why when because I've read this thing about 4 times.
Okay.
And I keep coming back to the same place.
Okay, where is it that is confusing to you? I'm sorry.
What I read to you.
Which was respondent to a complainant, that respondent had agreed to help the below respondent.
Right.
And that respondent, that respondent himself was a licensed surveyor. Number
I
4.
I understand that.
So how is that confusing?
The complaint is the same on 4 and 5.
That's right.
Have they wished or expressed desire to withdraw the complaints?
That's right.
Okay. Oh, I see on 4 it does say the last sentence there that the complainant wished to withdraw.
If they're wishing to withdraw, what are we talking about?
I agree.
Well, it didn't. Number 5 does not say that it wishes to be withdrawn as well.
It doesn't. That's why
It does not say that. I mean, had number 5 said that the complainant wishes to withdraw the complaint against number 5.
We received information saying the complaint was satisfied. Okay?
Yeah.
Satisfied with everything.
But that's in the narrative for number 4. It doesn't say that for number 5.
Well, but number 5 and number 4 are related. Okay? Number 5 was open because that was the, let me explain. That was the name given. So as far as the complainant being being satisfied, it's satisfied with the complaint that was opened against number 5. We opened it against number 4. Not the centralized.
I don't have any problem with that. I'm just simply saying the narrative for number 5, had it included the last sentence from number 4, I would have never had any discussion whatsoever about either of these matters.
Okay, well, I apologize. I thought I related the two together, so I'm
So
sorry.
what I'm saying is, by what you explained to me, I had to assume from the narrative of 5 that everything that was said in 4 applied.
Well, I'm sorry.
And I did not assume that.
I am sorry that
Again, I read them, even though I knew they went together, I read them separately and was trying to deal with them on their own merit and as they related. But I did not get that part that both of them were wanting to be dismissed.
Okay, all right. Lively discussion. It's all good, but I think we got the point here that that number 4 has the complainant on 4 has asked to withdraw the complaint. Am I correct? Just want to make sure I'm correct on that, Robin.
Yes.
I just want to make sure for the record I'm clear that the complaint does withdraw
Well, the
the complaint.
complaint is satisfied with everything and
Okay.
basically implied that,
Okay,
yes.
all right. And that applies to 5 as well, right?
Yes.
Thank you. All right, we got that straight. Okay, with that being said, I think we've had enough discussion on 4. Again, we're only addressing 4 at this time. We will come to 5. I expect that'll be brief. On 4, is there a motion to be made?
So moved.
Motion being
To dismiss.
to dismiss. Is there a second?
Second.
All right. Any more discussion? All right. We'll take a voice vote. All those in favor of the motion as stated, say aye.
Aye.
Any opposed? All right. With 4, that motion to dismiss was approved. On 5, is there a motion to be made? Read number 5 into the record, please.
Certainly, 2018-002271.
Opportunity to review those when you're comfortable with that. If there's discussion or a motion to be made, I'll take it.
I'm ready for a motion.
Go ahead.
Go ahead, state the motion.
Motion to dismiss.
Motion to dismiss on item 5. Is there a second?
Second.
All right. Any more discussion on 5? Hearing none by voice vote. All those in favor of the motion as stated, say aye.
Aye.
Any opposed? All right. With that, item number 5, motion to dismiss is approved. Okay. We got through the legal report.
Indeed it does. Thank
That
you,
was
gentlemen.
exciting.
Thank you.
Thank you, Robin, for your help there. Okay. I bet our guests from the Northeast had no idea what they were walking into when that happened. Oh, those guys in Tennessee, this will be a cakewalk.
They get those nor'easters. They know how it is.
With that being said, Mr. Carter and Mr. Tyrell, I certainly want to welcome you both and introduce you and invite you up to the podium there. Certainly want to welcome both of y'all representing NCEES. Mr. Tyrell from the Northeast chapter, is that right?
I am from Massachusetts.
I could
I'm
tell.
the chair of a
Right away. That was easy, wasn't it? That was easy.
And you have now been facially recognized with the state of Tennessee, right?
I trust you're a Red Sox fan?
Certainly.
Absolutely.
Bench bench clearing
We'll let
brawls
you, we'll let you have
last
the
night.
podium
I,
as long as you like that.
Great. Well,
Welcome,
as you
sir.
said, my name is Paul Terrell. I'm the chair of the Massachusetts Board. I'm a PEPLS. I've been on the Massachusetts Board for about 5 years now. I've been involved with NCEES for a number of years as well, fortunately. Here with me today is Jerry Carter. Jerry's the CEO. A couple of years past, former president, was it Pat? Dan Turner made a request to the council, was to do some reach out to the various boards that the council represents and come in and visit and meet them and advocate for NCEES, see if there's further things that the council can do and work with the boards. May I ask, are you gentlemen familiar with NCEES? Have you been to NCEES events?
Certainly. Yes.
So some of the stuff may be repetitive. You may know it all very well, so forgive me if I bore you for a bit. As we said, I'm on the Northeast Zone, and I'm the vice president. I'm one of the board of directors. As you know, NCEES is a national organization. It started in 1920 with 5, but I'm reading somewhere else, Jerry, that there may have been 7 members. I'm not sure exactly how many members started. Yeah. And it now includes all of the 50 states and a number of territories, and there are 70 members of our organization. It is a chartered nonprofit organization. It has 74 full-time employees down in Clemson, South Carolina. Have any of you gentlemen been to Clemson?
Yes.
Great.
He's had the pleasure.
A great facility that they have down there. Jerry's got a couple of announcements I believe he's going to make regarding that. The council itself is broken up into 4 zones, and it's great for me to be visiting with you. And I've never been to Tennessee or Nashville, so I'm enjoying myself for the very short time I'm going to be here. The governance of NCEES, it's a tiered organization. NCEES is the sole responsibility of the board members. And how that works is the council itself meets yearly, and they conduct the business. And then during the year, the board of directors manages the organization. And we meet 4 times a year. And then when we're not meeting, the CEO, Jerry Carter, runs the day-to-day operations of NCEES as a whole. During our board meetings, we discuss governance, we make recommendations, we handle the organization as a whole. The board of directors is for the 4 zone vice presidents, the current president, the past president, and the future president. That's the board of directors, and it's a nice group organization. It's a very interesting to participate. I've only been to 1 board meeting so far myself, and I'm learning fairly regularly. The council uses a number of different mechanisms to communicate with the various boards. There's licensure exchange that's issued 6 times a year. There are numerous reports. If you've been involved in NCEES, which I understand Tim has, we issue convention reports. There's the annual meeting reports. There are the board of directors reports, and all of that stuff is available to you folks for your reading and your participation if and when you make it to some of our meetings. We have numerous meetings, and there are zone, annual, and then the board of directors meetings. Have any of you gentlemen been to any of the board meetings or the zone meetings? Yes, sir. Great, great. The council creates does outreach to the boards through a number of different mechanisms. There's the NCEES.org website, where there's numerous bits of information on licensure and the progress that NCEES does on a regular basis. I myself have used some of this information. I do a yearly licensure, advocating for registration to the young engineers and the young land surveyors. NCEES does a great job of giving me information in which to speak to them. It's always fairly well received. I encourage you folks to be aware of some of this stuff and use it when possible. The council's got the MBA link. It's a secured website where MBAs can work amongst each other. I know that we have staff turnovers, and I know that when I became on the board, it's been a terrible learning curve, and I'm still learning all the acronyms from NCEES, so I really wish that if there was an MBA link, there would have been a new member link, so I can ask people what the hell half of the acronyms are that get used by NCEES, but I'm getting there. There's Law Enforcement Exchange, again, another secure website that allows communications about licensees, violations. I know that that's something that we in Massachusetts don't use to its fullest extent, and it's something that I propose or I'd like to see us do a lot more with. NCEES, as you know, they're the exam developers. But NCEES does a lot more. There's the council records program. I'm sure you folks are well aware of that. There's credential evaluations. Let me go back to council records. It's up to 65,000 individuals who use that database right now. There's credits evaluations. There's a staff of 5 that evaluate the degree applications, the degree of applicants. Do you folks wrestle with that as difficult as we do with foreign degree applicants and how they all work?
Not that I recall. Really don't get too many foreign applications here in terms of the surveying aspects of it. I'm sure perhaps the engineers probably do.
So that is something that we wrestle with all the time, and the council is very helpful with that. The council obviously does quite a bit of outreach through the public affairs. They attend numerous conferences. As I'm sure you can be aware, NCEES is partners with many different organizations, and NCARB and all the other acronyms, the alphabet soup that is these organizations. But it is interesting to go to the national meeting and see all of the various organizations that we partner with. And NCEES spends a lot of time. I don't know if you know, but the council president himself does somewhere in the neighborhood of 200 travel days a year, which is largely to get to all of these different organizations and make sure that the PEs and the PEs are properly represented across the country. Yeah, that's why you'll never see me as a council president. 200 days of travel is not something I'm interested in. The council's got numerous standing committees and task forces. The task force are typically assigned when something of some particular interest or nature comes around. There's a technology task force that I've currently participated in. It's mostly related to BIM. That's one thing that we've been tackling. The definition of surveying was another one that came up for quite a while that I'm sure you folks might be more interested in. The appointments in the committees, those are, I should say, the participants in those committees, that's appointed by the president-elect. I'm sure you folks have received the invitation to join various committees or task force, and so that's a pretty contentious situation that I think that the president-elect has to deal with. Again, another activity I will choose never to participate in is being able to identify who gets to sit on which task force and which committees. I'm sure Jerry could regale us with plenty of that. As a whole, NCEES is always looking for folks to participate and improve what we do. We look for suggestions and recommendations, and I myself, one of the things that is humbling for me is I'm a city kid. I don't know how I ended up getting where I am, a dual registrant. It's just from some hard work and some luck. And to sit on NCEES councils and meet with some of the people has been pretty impressive. I've been to lunches where I sat beside a nuclear engineer and a mining engineer, and I actually wasted more of their time asking them, what do you do? And how is it? What's a mining engineer do? Tell me all about that. So that in itself is the most rewarding part of NCEES, and so I would encourage everybody to do their best to try to participate whenever possible. I'm not going to talk too much about what happened in 2017 because I think that's an appropriate thing for Jerry, because I'm sure he can articulate it better than I. One of the things that we're going to chat with you about is some of the developments and some of the active things that the council is working on right now, and they include surveying matters and amendments to the bylaws. Jerry, what you want to handle some of those?
Yes. Most of you know, we have a task force that's currently, it was chartered by the council last year based upon a feeling and a need that professional surveying exam as it is currently constructed really doesn't serve the entire population. There are a number of the states, particularly the western states, public subject matter that was being covered was not adequate enough for a candidate who took the exam to be able to adequately demonstrate competence. So there is a review that's currently underway by the special task force, which has been created by President Tammy, to look at some modifications to that part of the exam, just the professional exam. And you're going to see some options. Hopefully I might see some of you in Charlottesville next week. Yeah, okay. I was going to say, I was talking about the president. Unfortunately, I get to travel with the president most of the time, so that means 200 days for me as well. So it's a lot of travel. But we'll be in Charlottesville next week. There was Western Zone was conducted weekend before last in Hawaii. This task force is presenting some options as to how this would be addressed, this issue and concern about the types and variety of questions that will be offered on the professional exam going forward. And we're talking about being able to better cover the land information, obviously colonial states, meets and bounds, some mapping sciences, potentially some photogrammetric. So there are some options about potentially coming up with a generic professional exam of some length, 4 to 6 hours, and then a division exam, which it would be subject to the state board. You would have candidates take that division exam based upon what you believe was needed for practice in your jurisdiction. So I'm telling you what you're going to hear part of next week, but that task force is looking for your reaction and remarks so they can then take next year and start to try to develop a plan. Pay attention to that group and give them some feedback, which is what they're looking for. There are some bylaws changes that are coming up. It's interesting because our bylaws, we don't even get into a bylaws committee unless the council has voted and it says go this way. But you have to go through the exercise now of officially having a group that says, yes, we're going to put this into our bylaws. The only reason I mention it is not anything that's too range too different. Is some house cleaning issues, but there is one thing that you will see. Last year, the council approved changing the term of the treasurer of NCEES. As it stands now, you can serve two-year terms, consecutive terms. And what the council voted last year and has directed the bylaws committee to come forward with a motion that says we want that to be 1 3-year term. That's it. But what happened is we also elected a new treasurer last year. So the question came up is what applies? So we've sought advice from our legal counsel on corporate affairs. I presented this to the board, and we'll discuss this too next week. Actually, at the annual meeting, the board is going to offer a motion that is at the direction of our legal counsel that says, basically in South Carolina corporate law, you can increase the length of someone's term, but you cannot decrease it once they've been elected. So what they're going to say is the board's going to offer a motion that says our current treasurer, Tim Rickburn, who was elected in this previous, that he is now serving a 3-year term, and the term will expire, and then bylaws.
With that, I guess one of the questions I have for you folks is how do you think NCEES can serve you folks better? And what questions may you have for us as a whole?
Well, the NCEES interaction with the Tennessee surveyors is relatively new, quite honestly. Of course, the FS exam has been administered for many years, but more recently the PS, we started using the NCEES PS exam. And then independent of that, Tennessee has always had its own state-specific exam, which until very recently has always been your standard pencil and paper, but now is completely computerized CBT examination. So the applicant in Tennessee, through the NCEES examination process and the state-specific examination process, it can be taken all CBT, with some of those allowing them to take the examination prior to being fully qualified for the horse, so to speak. In my experience, it's been a success. Most of the interaction involved between NCEES and the board itself is administrative. We just kind of overall oversee it, approve the applications for them to take the NCEES exam. Positive process. I think the CBT exams are working. It is new, it is different. Some of the younger surveyors coming through are not struggling with it. I've heard some stories of some of the more experienced surveyors trying to get licensure, sitting down to a computer screen, kind of going, what in the world is all this? Whatever happened to the pencil and paper I took back in school, But I think overall that will work its way through in a more positive light as the process works its way. It's just a matter of time. But in the big picture, it's been a great.
Well, let me ask a quick question. So when you say your experience with NCEES is relatively new because you had your own state-specific, is NCEES providing more services for you now?
It's been a relatively new process where the professional surveyor examination we've now accepted using the NCEES exam. We had our own professional surveyor exam here in Tennessee, similar to what we mentioned earlier that Texas does.
So that was a 6-hour or an 8-hour?
It was 8 hours.
Okay, so
yes.
They didn't have to take the national NCEES PS exam?
That is correct.
Oh, okay, now I get you.
Used to, but now they do.
Now you do, okay, go ahead.
We saw the light. And it was a standard pencil and paper.
It was standard pencil and paper.
Under the premise of the board drafting the examination, administering the examination that we proctored out.
So we in Massachusetts still have a state-specific pencils and paper, and nobody wants to address the 800-pound gorilla in the room, which is we are going to eventually need to go testing, and folks don't want to. How did you tackle that? Can you help me?
We were there.
Yes.
We were there. We were very fortunate to have the testing agency to work with the state in and administer that exam. Probably staff here could probably help us out a little bit with, if you want specifics. You might want to ask for that on the side at a later date sometime. But we were able to work with them. Financially, it is probably an issue there. It is cost prohibitive, especially based on the numbers. I mean, when you get down to it, it's the numbers of examinees versus the cost of the examination. Here in Tennessee, we don't have a whole lot of applicants. Certainly not by the hundreds that some of the larger states, the Californias, New Yorks, those states may have. But we were able to work with the testing agency and try to solve that as best we could. Obviously, it's a state-specific.
Yeah, we're going to have that problem in Massachusetts as well. I don't think we administer more than a dozen state-specific exams a year to the budget, and to move to computer-based testing is going to result in, we're going to need money to be able to do that. So I think that's part of the reason why nobody's tackling it. And as I've been the chair now for a year, guidance and some advice moving forward. So your involvement with NCEES is now new. I would encourage it, but you folks have participated. You understand the organization as a whole. You understand the resources that are there for the council that we provide, or the council provides. Some of the things that are more interesting is some of the arguments. They may not be survey related, but I know that I have a passionate disagreement with some of the council's items, and so it's good to hear other people's voices as well. For instance, California, we mentioned California a few times, and their zeal to license. They license folks before they are. I shouldn't say they license them. They allow the PE exam to be taken before the experience is there. So that's an ongoing discussion. It grows in the council, and so voices, pro and con, are always helpful in that regard.
We do allow that for the FS exam, isn't that right? But not for the PS currently. We've certainly had discussions on doing that, but we do allow that for the FS.
Yep. Things that it changes the way some of the councils, should say the board's regulations are written, so it creates an exercise for us all. I know that we're tackling that in Massachusetts as well.
It does, and primarily it was a matter of efficiency and encouragement. We want applicants to get licensed, and just the fact that the experience was being delayed until the examination process, we just kind of scratched our head and said, why? Why do we do that? Why don't we allow them, if they're ready to take the exam, and then allow them to gain the experience on the back end, such that once that experience is gained, they obtain that stage of licensure.
With that, I just mentioned one thing that I don't think we did mention is that you've got your zone meeting coming up. There's an interesting thing coming up in 2020 where there will be a combined zone meeting. I'm a little lost as to whether or not, was that 2 annual meetings then at that point, or is it just? So in 2020, when we find a location that can adequately accommodate the size of the meeting, we'll have 2 annual meetings as far as I'm referring to them as. But with that, that's what I had to come and visit with you folks. I want to thank you for taking the time to speak with somebody from New England, which I think I'm glad that you recognized me when I walked in the door, or at least the way I talk. So I will say, I'll take a moment to remind it, as I tell everybody when they do comment on my accent, the country began where I'm from, and I speak correctly, and all of you folks have.
Paul, I did notice that you did not throw out a "use guys," which was great, but if you stick around here long enough, we'll get you to say a y'all before you leave.
And we will ask you to pronounce, I'm going to call it Wooster. Yeah.
Well, thank you very much. I appreciate all of your time. If you have no more questions for me. Thank you.
We appreciate your time and coming.
Paul, it's been wonderful.
Do a very good presentation.
A couple of things.
Absolutely. More than welcome.
Bullet points. First thing I wanted to say is that we don't exist, and too often it gets to be it's NCAA is almost like 2 organizations. It's NCAAS, me being down at Clemson, and it's NCAAS being the boards. There's only one NCAAS, and it's you. And we at NCAAS and Clemson don't do something unless it's serving you, NCAAS member boards. So make sure you understand that. assistance, and we do have a number of services that we hope you will avail yourself to in terms of our council record program, credential evaluations, outreach. We are spending significantly more money on outreach on surveying. It's just the nature of the world and the population and the reduction in the number of people. But we're such a fortunate organization. We have between 800 and 1,000 licensed volunteers who come work on our exams, and I get to see Tim at the building quite a bit. He works on the EPS committee. People who we pay for their expenses to fly in, we pay for the hotel room, we give them food and drink, and they work for 3 days and have a smile on their face, and I'm just always absolutely amazed by the level of volunteerism and professionalism that we get from professionals just giving back for the professions. 2 things I will tell you: the surveying exams are completely computerized. The engineering exam, unfortunately, because we have 25 different disciplines of the PE exam, we've got a 5-year transition plan. So that's going to be with some pain. We know how to do it. It's just we have an individual committee for each discipline exam. We have to come up with new reference books. Some of these exams will not be offered year-round based on the population. Will still be one-time events. So that's what's going to keep us all off the streets for the next 2 or 3 years in Clemson. The other thing I'll tell you, I hope you got a press release. We were very happy about 2 to 3 weeks ago. We were able to resolve an ongoing issue we had with a test prep company that we've been battling for about two years, and we received a $1,000 cash payment that went into the coffers of NCEES, and this group is taking out all of our items. So we jealously guard our intellectual property. We do a number of things to try to protect it. We have programs of shoppers, where we'll pay for people to go in to take review courses and then come back. To be going straight and narrow, but the point is, I work for you. When we can help you do something, let us know. We try to work as a body to try to make everything better, to make what you do better, to make the process better, and ultimately make what the public receives better. That's why we exist in this. So
If I might, I'd again personally like to thank both of you for coming today. I enjoyed what you had to say. I'd like to make a comment to each of you about something that you did say. Paul, the first time I participated in an NCEES meeting was in 2009, and I found exactly the same thing that you commented about sitting between a nuclear and a mining engineer. There are so many intelligent, professional people that are involved in the jurisdictional boards that come to the NCEES meetings. I'm just an old country redneck from East Tennessee that surveys every day out in the dirt. And it's such a great privilege and pleasure to be around those folks and to learn and just to listen. All you have to do is sit and listen. You'll learn a whole lot from each and every one of them. And to Jerry, what I wanted to say to you is, I've been to Clemson many times, as you well know. I've been involved with several committees and different things as well. But the thing I want to relate to you is your staff is absolutely tremendous. Whether it's somebody I've only emailed with, or whether it's someone I've spoken on the telephone with, or whether it's the folks that I've met and actually dealt with in Clemson, they are absolutely amazing, super courteous, always helpful, and you just can't say that about every stop that you make with every group that you work with. But I just wanted to let you know that that's what I see when I come there, and the reason that smile's on my face after 3 days worth of work is largely because of that, because of how we're treated and how everybody just jumps in and works together. It's just a wonderful environment, and I want to personally thank you. I know you're getting ready to leave us. I hate to see you go, but I want to personally tell you I think you've done a wonderful job, and a lot of the things that I've just talked about are largely because of your involvement and many, many others. I understand that, but again, I want to personally thank you and wish you the best in your future endeavors.
Well, thank you, Tim. And I will respond to that by telling you that the staff at NCEES make me look like a genius every day. I appreciate that. One of my efforts almost every day we go into meeting is for me not to be the stupid one in the room, and I'm going to take credit for hiring smart people. But the other thing I'll tell you is my experience goes all the way back to 1984. I worked for the North Carolina board. I was the executive director for the North Carolina board. So what I saw when you started your meeting here, it took me back in terms of remembering that and how much time and what effort you have to go through.
Thank you to both of you. I know you mentioned 200 days of travel time. I feel a little bit guilty thinking that we just took up another 2 of those of your 200. But your presence here is very much appreciated. It really bonds the connection between the boards here and the parent organization of NCEES. We very much appreciate your time and effort to come to Nashville, come to Tennessee, and make a face and show the surveyors and engineers, obviously, that the board is there and that you do exist, and you come and you take care of the member boards as well. So we duly note your time, your efforts, and your presence, and certainly welcome, and I hope you enjoy your time in Tennessee. Y'all enjoy.
Good rest of your meeting.
Thank you. Appreciate it. You're more than welcome to stay with us. If you'd like to hang around for lunch, we'd love to take you to lunch with us.
The engineering boards over here?
Yeah, they're next
Yeah,
door.
absolutely. Absolutely.
Mr. Chairman, I'd request a 5-minute break.
That's an outstanding request. We'll take that 5-minute break and maybe make it 10.
I wonder if they're going to speak to us. So they signed in the district.
Really? I was thinking they were legal staff, maybe. We'll find out. He administered. Thank you, Glenn. All right, we are back from our 10-minute break there, and we are back on discussions in dealing with the educational report. We had 2 items that originally we had put off for further discussion. Jamie kindly got some additional materials for the applications for both Mr. Thomas and Mr. Nettleman, and currently we're reviewing those applications for the additional information that we were requesting. Real quick, Mr. Thomas's application, I believe, is just what I think is going on here. I think there is some confusion here as to the request for the CER number. It's my understanding that his audience is students, not professionals that are seeking PDHs. Rather, I think there's some confusion here as to how Mr. Thomas can apply for PDHs himself as the instructor, which the current rules allow for him to do, and without necessarily needing a CER number for the class that's provided. I think I have that understood correctly. So is there any other understandings from members here?
No.
I think we have that right. So I think we're not going to issue a CER number based on that. If Mr. Thomas has, if I've misunderstood Mr. Thomas, I'm sure he'll be back in touch with us. We'll address it again, but that's the way we got it right now. So we're going to.
Do we have to vote on that?
We will.
Oh, okay.
We will. We'll get to
Gotcha.
that one. I want to address Mr. Nettleman's here first. Again, Mr. Nettleman, Dr. Nettleman, no disrespect, from Texas. The course is entitled Texas RPLS Prep Course. He's requesting 8 hours of PDHs for that. It appears to be an online course. It does involve, based on his syllabus here, item 3, acts and rules, 100 minutes worth of specific rules, practices, procedures specific to the state of Tennessee. In fact, he gives the web link. Texas. I'm sorry, Texas. Oh, it's important I get that right. Yeah, Texas, specific to Texas. So obviously, in my opinion, I don't think those specifically would qualify to Tennessee specifically. There are other items here that probably do migrate over to the commonalities between surveying in the 2 states. I did see, however, this is in an email, I believe, from Dr. Nettleman addressed to Dennis on January 31st. In it, he says that the courses are offered online format. Students purchase the course on the website, gain access an e-learning platform, includes slides, videos, exercise, quizzes. Then they take a full-length 8-hour exam, parentheses, simulated RPLS, to get the certificate of completion. Again, this is specifically for obtaining the Texas RPLS prep course. So I'll leave it up to the board here, the other members here, to comment on what their opinions are. Right now, I'm not inclined to give the full 8 hours as requested, specifically because there are, again, the 100 minutes specific toward Texas. But I'll leave it up for discussion as to whether we want to issue a partial or no hours at all.
What do, go ahead.
Well, no, go ahead, Jeff.
What does SPMTX mean on that syllabus there? Is that some sort of Texas measurement, something?
Yeah,
or other?
Spanish, Mexican, and
Spanish.
Texas measurements.
Oh, okay.
That's what I would infer that to be.
I think you're correct. Obviously, in my little knowledge of Texas, there is quite a bit of Spanish and Mexican influence
Right.
there, especially in their measurements of veras and different values for the vera measurement units. Obviously, I don't know that those apply to Tennessee. I've never run across it in Tennessee. So that may be another aspect to take into account here.
Well, when you look at it, his summation of his minutes equals 720. When you look at things that relate to Texas public exam, et cetera, that's 450. So well over half of the time that's been involved does not deal with what I feel like may be Tennessee. So, my notion there, that would be, let's see, 720 minus 450, whatever that is in the real world, 270, which would be divided by 60, be about 4 hours. My notion is if we approve anything for this course, it would be no more than 4 hours.
Jackie?
Well, I got a question. Thought is, if we reciprocate with other states, in other words, if I get PDHs in Kentucky, they apply here, and we're both meets and bound states, but there are some differences in the specific laws. So I don't know that I see this as being much different. That's my thought.
Let me ask you this question then. Since Kentucky requires 8 hours annually and Tennessee requires 15 hours annually, if you had dual offices, one in Tennessee, one in Kentucky, which you could do and be licensed in both states, would you not be responsible for both the hours limit in Kentucky and then be good in Tennessee?
No, but you could apply what you have in Kentucky toward the Tennessee PDH.
Right, but you'd have to still have 7 additional.
Oh, absolutely.
In that particular example,
Absolutely.
is that correct? Okay.
Yes,
Okay.
yes.
Okay.
So Jackie, you think there's enough overlap to just approve it all for what?
Well,
There's a difference. There's a difference
Right
between
here.
Tennessee and Texas. I mean, a big difference. They're a public land state, so there's a lot of different principles that have to be applied there. But I tend to lean toward approving it all because it is serving in my opinion, the purpose of gaining some extra knowledge. Purpose of PDHs in the first place.
Mm-hmm.
Well, all right, let me ask this question. Let's just go right here and try this. The outline says it's a preparatory exam for someone that is not licensed. Would you anticipate a licensee in the state of Tennessee taking this preparatory exam unless it was their intent to become licensed in Texas?
Probably not.
Okay. With that spirit in mind,
And I probably
that's why I'm where I'm at.
I probably don't see very many applying to take an 8-hour exam
Right.
for PDHs.
Right.
I mean, being required to take that. So, but if they so choose, we probably need to give them that option.
So primarily the audience that he's after is the unlicensed in Texas, unlicensed, hoping to gain licensure in Texas. So how would that give value to a person who is already licensed in Tennessee? I miss the overlap there. I'm more inclined not to approve the request for PDHs. Myself, Tim, you mentioned 4.
At max.
Max
At max,
4.
and I'm leaning more your way now.
Jackie, Jed.
I'm fine with 4. I don't see many people using this who need it for Tennessee credit anyway.
And it's the class is geared toward the unlicensed professional already. Well, the audience that we're after is the already licensed gaining additional PDHs.
But
I
if
see
you
a
look
little
at,
bit of
if you look
conflict
at some of his topics, though, they're the same thing
Oh, I agree. I
that
agree.
we hear
I agree.
All the time, right.
in every seminar you go to.
I agree. I agree. I agree. All right. Unless there's further discussion, we'll address these separately. Both Dr. Nettleman and Mr. Thomas there will address those separately. I'd like to address Dr. Nettleman's first, his application there. Is there a motion from the board here for approval or denial or some value to the PDHs if you are inclined to approve?
Well, no, I was going to say, and I'm not opposed to limiting it to 4 hours either. So I would be
Put that in
willing.
motion?
I'll put that in form of a motion that we limit it to 4 hours, as Tim
Okay.
referenced a moment ago.
Okay, so the motion is for approval of his course with a limit of 4 PDH hours.
Yes.
Okay, all right. Is there a second on that?
Second.
All right, I do have a second. Any further discussion on after the motion and second is made? All right, hearing none. By voice vote, all those in favor of approval of the motion as stated, say aye.
Aye.
Any of those opposed, say no. I'll say no. All right, with that, the motion is approved on a 3-to-1 vote for Dr. Nettleman's for 4 PDH hours. All right, separately, I do want to address Mr. Thomas's application. Again, I think there was some confusion on the applicant's part here as far as obtaining PDHs. I believe it's for personal gain of the PDHs as an instructor, which is already allowed under the rules as they exist. Again, his audience is for students that are not licensed, I assume are not licensed and are not looking to gain PDHs themselves, the students. So I think there is some confusion there. If there's a motion for Mr. Thomas's application.
I make a motion, we approve it with the non-CER scenario because he's an instructor. Of course, that he has stipulated.
Okay, fine. All right, with that, is there a second for that? All right, not hearing a second. Not hearing a second, is there a second?
No,
Okay.
I have a question. Yeah.
All right, well, we can handle questions if there's a second.
Right.
If there's not a second, the motion will die.
Let's move on.
All right, not hearing a second, last opportunity for a second. Not hearing one, the motion is dismissed. Is there another motion on that to be made for possible dismissal of the application?
I'll make that motion.
All right, you state your motion?
Motion to dismiss the application for CRE approval.
By Mr. Thomas, is that correct?
Correct.
Okay, all right, we do have a motion on the table there. Is there a second?
I'm going to second so I can ask a question.
Thank you. All right, we do have a second on the table. Now we can open it up for further discussion.
My question is, how is his motion different than mine?
He's denying the applications.
Oh, he's going to deny the
Deny the
application?
application.
All
I would
was gonna do
request
is-
an amendment to the
All I was going to do
motion.
was to get rid of the CER number.
Well,
I think we're going to end up the same place.
we are going to end up at the
Okay,
same
then
place.
that's fine, that's fine.
I would
Yeah, it's the same
request
place.
the amendment to the motion that, in addition to denying the application, we instruct the staff to send him a letter with an explanation that when he provides his PDHs, that he'll still be able to use this time. I want to make sure he understands
Yeah,
that.
yeah, we're not denying his time.
It's in the rules.
Right.
It's in the rules.
It's in
Yeah.
the rules.
So just a letter of instruction on what he.
Right, that it's already in the
As
rules and all he's got
Yeah,
to
he
do
just
is
needs to
turn
look
it
in
in.
the continuing education rule and see what it says.
Okay.
Yeah, and actually, in all reality, he probably could have got more hours than what he asked for, in all reality, by the way it reads in the rule.
Real quick, Jed, I know you made the original motion. Do you accept the amendment?
Sure.
Okay. All right, so the motion has been amended. The original, I need a second to be made as amended.
Second.
All right, second is made. Any further discussion? Hearing none, all those in favor of the motion as amended, say aye.
Aye.
Any opposed? All right. That is approved for the denial. I think that's right. I think I said that right. I think I said that right.
Hey, you did good.
the CEO.
Brad, if you're
That's
confused
right.
as
We
I
got
am,
there.
call me.
Well, there's more than a couple ways to get there, but we got there.
Yeah,
Okay, I think we got there. All right, all right. Let's get back onto the agenda. I believe we're at the director's report, am I right?
And I think Miss Sarah still got something,
Still
don't
have a
You
little
still-
bit
I'm
under
sorry.
legal.
I apologize, I apologize.
So just
Jump
wanted to
ahead.
give an update that the GPS rules are effective as of yesterday.
Yes.
An e-notify did go out, I believe, a couple weeks ago saying
Yes.
that they would be effective. I'll probably try to get another one out today or tomorrow stating they're officially effective. So That's all we have on rules. Legislative update. I put a bill up on your desk, House Bill 2248, which is Senate Bill 2465. It's called the Fresh Start Act, and I'll just read you a brief summary. The bill prohibits any licensing program attached to the Regulatory Boards Division from denying an application for licensure for a criminal conviction that does not directly relate to the occupation. We will not have to make any changes. Our statute currently says that you all may refuse an applicant for any conviction of a felony that bears directly on their fitness to be competent in the field of land surveying. So essentially what will happen is there's a list of factors within this bill, and they're on page 2, part 4. So if you all were to deny an application based on a conviction, we would probably most likely bring it in front of you and ask you to look at these factors and make sure that you're taking them into consideration. That way, if we're questioned, if they appeal to Chancellery Court, we can show them that you all went through the proper steps that have been asked of us in this denial. The other bill to bring to your attention is House Bill 2537, which is also Senate Bill 2458. And we are calling this the apprenticeship bill. I did not give you a copy of this yet because it is not passed yet. It is, I believe, with the House today on the regular calendar. So we will be following this. But it essentially it gives boards and commissions the ability to create an apprenticeship program. The federal government had a mandate not too long ago that they thought that was important, that we try to bring people into professions in that manner instead of, always requiring that they have, a college education, that maybe someone can learn from apprenticing the same thing somebody can learn from going to college or, going a certain route. So basically this, the amendment that we've currently read will not require any board to create an apprenticeship program, but you now have that ability to create an apprenticeship program.
Was that, I don't have a copy of it, but was that affecting all of the licensure boards, or was it specific to specific boards?
It empowers any program attached to the Regulatory Boards Division. So everyone that's housed in this building, so.
So it's not a mandate?
It's not a mandate, no.
Okay. Do we know if it's going to pass? You probably can't make that assumption.
I mean, in my opinion, I think it will probably pass just because it is a good bill.
Sure.
I mean,
okay.
So.
If and when it does pass or does not get any further, could you notify us?
Yeah,
of
we'll
that?
let you know.
That'd be great. Great.
I think we're already there in a quasi situation in that we allow the 10-year and beyond.
Yeah, absolutely. And I know the new bill has some carve-outs for certain regulatory boards. For instance, I have auctioneers, and we have an apprenticeship program already, so we're not going to be, even if it was a mandate ever, we wouldn't be required to do it because we already have one. Or even real estate agents, they have 2 levels. They have an affiliate, and you have to be an affiliate for so many years before you can ever be a broker. So, but that's all from legal.
Outstanding. Good stuff here. Yeah.
Got some technical difficulty over there, I see.
I'm not technologically savvy.
Okay.
I'm trying to get the director's report so I can see what you're going to tell us. I can't get there from here.
All right. Ms. Sarah, thank you for that information.
You're
Well
welcome.
done. I appreciate everything you've done there.
And I know I said it when we were on break to Tim, but there will be a change in the structure. So next time we meet, I will be sitting here in this capacity, and then I will also be doing the legal report. So everything will be through me from now on. So
Excellent. We look forward to that.
one
Thank you.
attorney.
All right. I believe now, if I didn't jump the gun, are we now ready for the director's report? Great. Glenn, I'm looking forward to hearing what you have to say.
Hey, bless you. Thank you, Glenn.
Thank you, Chairman. If we will, we'll just jump in on the budget. For the benefit of our new member, I'm going to go over some stuff that's probably familiar with to you, but nonetheless, just to kind of take advantage of the opportunity to break that down a little bit more. If you notice, we got 3 pages on the budget. The first is your trending, the second is your expenditures, and the third is your revenue. So you've got basically, we're tracking the trending, and that's basically like your dashboard. And then all the data that feeds into your dashboard is page number 2 and 3. Okay, so if you go back to page number 1, we'll spend some time there for just a moment. And at the very top, you've got your revenues, and then right below that, you've got your expenditures, and then the line below that is your net surplus or deficit. And then we track that through the fiscal year by month. And so also, for the benefit of our new member as well, we have a 2-year renewal cycle. So we will run in a deficit on the off cycle, but we just went through renewal period, and we're going to give an update right there. So you'll notice that we're in we've got a nice surplus there for about 1, 2, 3, 4, 5 months, but now we're back in the red because that's pretty typical. We understand that, and the renewal cycle always because that spike in revenue will account for whatever expenditures we have on the off cycle. So that's where we're at on that one. Licensing, let's just look at revenues. You've got the different categories. You got licensing revenue. That's because of the renewal cycle, we're going to have a spike in revenues there. Case revenue will be some of the judgments that we did today when we were going through the complaint report. Any of those that were rendered and paid, then that'll show up there. State reg fee. We've got fiscal. They print out the licenses for us and they charge us $5. So that's basically. It's not a true expenditure in the sense that it's basically I forget what they call it. It's a revenue reduction. I didn't really know the difference, but apparently when I'm talking to accounting, that is a real thing. So they're just saying it's a reduction in revenue in the sense that it's a workaround, really. We just don't have necessarily the capacity, so they just create a line item for that. So roughly, if you've got 900, well, if you notice. 4,000 in January, 4,000 reduction in revenue. That's because they're printing all those licenses, and it's $5 a pop, and some duplicates and stuff like that. So that's what that is. If you go down to expenses, you've got Edison expenditures. That is, if you go to page 2, there's an itemization of those Edison expenditures, and administrative costbacks are very similar to Edison expenditures. They're everything in some of those categories are the same, but they're the total of all everything that wasn't automatically tabulated in Edison, and then divided according to program based on size and based on complaints and those type of things. So that's what you got Edison or administrative costbacks. Legal costbacks are the billable hour of our legal, and if you notice. While we're there, January experienced a spike, and that's going to be when they're working on bills or working on, if you have a really large case report that requires some extra time, then obviously the billable hour that'll start to add up. So that's what we have there. Investigators, field enforcement. When our folks go out in the field, if we have to hire an expert or somebody like that to go look at something or to evaluate something that could potentially show up there if they invoice us. And then, of course, our customer service center. Those are the folks handling our calls, our first line contact. And so that's where those numbers come from.
Is that based on the number of calls they receive that pertain specifically to this department, or is that just like a break?
It's a percentage. They keep it just like administrative costbacks. They track that and then break it down accordingly. So as far as let's talk about overall health, and we'll talk about the last couple months individually. Overall health, for the fiscal year, we brought in a revenue of $299,900, and expenditures were $85,000, giving us a net surplus of $214,000. So that's pretty good. That's about what we expected. And so that'll carry us through the expenses till our next renewal cycle. We don't anticipate any change there. Now for individual month, let's just look at January in particular. January, you saw a spike in expenses there. That's atypical from the other months. And the reason why that was there's two reasons for that. One was a quarterly billing by STS, which is the IT arm of fiscal. And so every program's getting hit in January for that expense there, that quarterly billing. So that's that piece. The other piece, too, is the PSI consultation fee. We were invoiced for that. We're working on the test. We're going to talk about that some more. So that's why. That's an isolated spike. We don't anticipate that'll continue to trend in that direction. But for the month of January, we're going to see that spike there. Other than that, I don't think there was anything else that looked abnormal or anything that jumped out at me, unless there's something jumped out at you folks.
I have a dumb question. What is Edison?
Edison is our basically our clearinghouse for it tracks our expenses. Our employees will clock their time there. Anything, basically, it's our fiscal clearinghouse for everything that has to deal with accounting, whether that's employee expenses. And one of the things that's on Edison, if you go to the second page, you can get a kind of a breakdown of what's in Edison. That first category there is the employees, the labor that goes into land surveyors. And then below that, you've got everything entered in there from office furniture, supply, rent, phone lines, fax lines, those type of things. Third party, if we get a vendor invoice or something like that, all of that gets entered in Edison. It's one place, a portal where we track all of our expenses to include payroll.
Yeah, and Jed, you will either become to like Edison or not like Edison based on if you have issues in getting your check after our meeting. That's the easiest way to tell you.
Yep. After today, you sir will be in Edison like everything else.
They're going to put you in there, so good luck.
Whether hard assets or personnel assets, they're all in Edison.
That's right.
Yep. Okay.
Statewide, I mean, like TDOT, that's.
But they're all in Edison.
Paid through TDOT.
Does anyone have any questions on budget?
I don't believe so. I think
Okay.
very well covered. Thank you.
If we can, let's move on to NCEES annual meeting. As we know, they have their annual meeting about in the fall, and this one is no different. It's August 15th to 18th. It's going to be just outside of, probably not news to you, but it's going to be outside of Phoenix, Arizona, in a bedroom community outside there. And so they have 3 funded delegates. So we just have to select who those 3 funded delegates will be. So if anyone wants to make a motion to that regard to assist, that would be great.
Tim, you got something to input on that?
Well, I am funded because I'm a Southern Zone officer, so that leaves the others to be, so.
So I guess it's a matter of what does your schedule look like? Does anyone have any, maybe anyone have
What
any?
were the dates?
It was August the 15th through the 18th. And
It's a Wednesday through Saturday.
Are you going to go, Miss Sarah? So we can carry. Actually, here's the good thing, Jed.
I won't be going. I have a child due on August 3rd. That's
okay.
my wife.
she probably would like
I was
that.
just going to tell you that whenever you do decide to go as a first-time attendee, your trip is paid for and is not part of the 3 attendees. So having said that, then we need to include Miss Sarah as a funded delegate with Jay and Jackie then.
What's
Does
funded?
that apply? She said.
I'm a first-timer.
Oh, you'll be a first-timer? Okay. If you've never been to the meeting, then you'll be paid for. So we
3
still
funded.
have one.
So 3 funded are board members, but then
Glenn's
the first
going
time.
then? Is that
Are
what
you going, Glenn?
I think so. Roxanne's going to be there as well. So,
Okay.
But it won't be probably funded just because they have 3 funded board members and then 1 first time.
Have you ever been?
I haven't, but it's got to be a board. I forget what it's called. Board member administrator. It's a bureaucratic thing, but nonetheless, Roxanne is listed as that. So as a result, and she's already been. So that's kind of how that.
That's fine.
Okay, so it sounds like the funded delegates, as far as the board members go, will be myself and Jackie. Jed obviously offered the opportunity. You want to call the wife real quick?
No need to.
Next time.
That's probably a wise move. And then, of course, with Tim being covered from Southern Zone, it looks like we'll only be able to take advantage of 2 of the 3.
Well, Roxanne will go with us then.
Okay.
She'll be there. I think.
She'll be funded. Yeah.
Okay.
Yeah.
Okay.
And then Sarah get to go first time.
Right. Excellent.
So if someone wants to make a motion to that regard, then we can move on.
I'll
to
make that motion.
All right.
That motion is made. Then.
Second.
And seconded.
All right.
Any further discussion? Voice vote. All in favor, say aye.
Aye.
Any opposed? All right. There we go. That was easy.
The PSI update. Now, I imagine Mr. Lingerfeld will have some more to elaborate on that, but I'll just, if it's okay with him, I'll just give kind of the
Right
brief
ahead.
introduction and let him fill in the gaps, because I'm sure there'll
Okay.
be some.
Go
So,
right ahead.
we talked about in the budget that invoice for PSI consultation. If you remember, we just went live with the Tennessee Specifics exam, with PSI as our vendor. We've had about 15 take the test. So with all tests, they're constantly reviewing those. Tim is no stranger to that, does that with NCEES, with some of our other tests as well. So PSI, they're no different. They want to assemble a panel, a small group, about 1 board member, 4 experts, and then they're going to do a webinar or WebEx, to kind of assist some of the new participants that haven't built exam questions to assist them how to do that and explain the process to them. Obviously Tim won't need that tutorial, but some of the ones we bring on that small group, they will. So that's going to happen on the 14th in May. And that's all we have as far as that goes. There's nothing new except we'll have some more information after they get done with that test or that webinar. We probably have some more updates then, but right now that's what we have in the works. Tim, did you have anything you want to add?
Basically, just real quick, trying to get the group together, webinar, and get them up to speed. Then we're going to do some independent work, and then probably sometime in June we're going to actually meet at a site, all of us together with questions and tweak them, so forth and so on, so that we can try to get them added into the bank for the examination. Because PSI has a different approach to CBT examinations than Pearson VUE, who administers NCEES. So it's the same, but it's a little different.
Fascinating process.
Yeah.
I got to experience it with the auctioneers, and after seeing that, I was because you take these tests and you think they just fall out of thin air.
I was going to say, Jerry and Paul talked about the exams earlier. The last time I was in Clemson, they told us that a individual question on either the FS or PS examination administered by NCEES.
Oh, I believe it.
And that does not include all the questions that are in the bank. I mean, whereas if you're just looking at the 100-question exam, that's $2,900 for those questions. But you've got another 400 or 500 questions that's in the bank. There's another $2,900 for every one of those.
Oh, it's very scientific too.
Yeah. Oh, yeah.
It's amazing the analytics they have on each of those questions. It's amazing.
The greatest difference between PSI and Pearson VUE is PSI does not like negative questions. All the following are correct except PSI will not take that question. They will not take it. Where Pearson VUE will take that question. And with NCEES's experience, they have found that those are very good test questions the way they're presented. So just a little bit of both sides.
That was great. Good information. Thank you, Tim. If we may, then we'll move on to the renewal status.
Can I ask real quick one question?
Yes, sir.
I think you said there was 15 that had taken
thus far. That's correct.
online. Do we have an idea of the pass rate on that, of the 15?
Last time we checked, there was, it wasn't quite 15. It was right at 10, and they all passed. But then,
all passed.
But
okay,
I haven't looked at anything after that one. So, yeah. Okay, there we go.
Thank you.
Okay, the renewal status. As you know, we talked about that in the budget as well. We saw the spike in revenue, so we went through a renewal. We had 120 individuals that had not yet renewed by the end of February. We sent out an email to all those folks. Now we have 89 still pending. Okay, so some folks did tighten it up and got it done. The last notice of temp will be tomorrow. We've got letters lined up, and we're going to send that out as well. We're trying to hit them every way we can, electronically, letter. That'll be the last attempt from the office to remind the licensees that they're expired, and of course they can't work. They're expired, so that could pop up in the form of a complaint down the road. But
ask a question on those late renewals. In the letter that is sent to them to remind them, hey, you haven't renewed. What's the deal? Is it also contained in the letter that during this time that their license is not valid? And then secondly, is there a late reinstatement fee for their late renewal?
Yes.
There is a fee associated with all those actions. That's correct,
Okay.
and assessed also for just each month that they fail to remove as well.
Okay, and I just want to make sure that's being followed through. That in these 200 now down to 89, I think you said that those 111 are saying yes, I do want to renew, and here is my late fee.
That's correct.
Okay.
That's happening.
By our rules, the ones that I'm concerned about are the ones that have not turned their PDHs in because they really are not legal. The ones that have not paid have a year's grace time, basically, by our rules. Correct?
So that's what I was going to bring up. I know this was when we talked about this, 6218 114C was what we talked about last time, and it's the 1 year. And I know Tim had asked me to figure out when that went into effect, and so I did some research. And it looks like it was added in 1998 with a $20 penalty per month, is what the statute actually specifically stated. And then in 2001, it was changed to allow the board to set a monthly fee. So this statute has been in effect since 2001. Yeah.
Good job, board.
So,
Breaking in that money.
Well, as I've said before, I do not like that. I think it should have a more dead end. In other words, if it's 90 days, and like in Virginia, if I miss, I got 90 days and I don't perform, then I'm out. So I wish when we look at our legislative wish list for next year that would be one of the items that.
and we
have
should
on.
talk about that at our next meeting. That should be when we handle proposals
Because I
for the
think we need-
2019 session.
I just feel like that the PDHs and the dollars need to be more intertwined instead of independent. Right now, they're kind of independent, and you can do one or the other basically, and it puts you in a different environment. And I just don't think that that's a good way of managing for the staff.
Yeah, and I know Jamie would probably have to correct me because I've got about 20 boards going on in my head right now, but a lot of my boards do a 60-day grace period. So 60 days after you expire, you can just automatically reinstate your license if you turn in everything necessary.
Right.
But then most of them still allow that 1 year time frame, but you have to pay a late fee every month. And so you can't be reinstated. I had real estate yesterday until you pay $1,080. So the $80 is your renewal and $1,000 is the penalty if you're there. And so if you want to be reinstated, you have to, otherwise you hit that 1 year mark, then you have to retest, reapply.
What's the process of reinstating? Is it all paper, or is it online, or how does that happen? During the 1 year grace period, though, what's the process of turning?
They just turn in everything.
And it's just mail, or is it's online, or they call you? Okay.
The state is trying to go completely paperless. That's
That was my idea, but I wasn't sure.
we still have a lot of people that mail things in, but
They do,
our
but
goal
the
is.
majority now is online.
Okay. Thank you. We're supposed to talk at the next meeting about jacking up the rates. Is that what we're talking about?
I will tell you,
Legalese?
we typically don't raise any of our rates. The legislature typically frowns upon fee increases. Now, if you want to go to $15 a month, they might.
I thought you said in 2001 it was changed to allow us to set it at whatever.
Yes, so in 1998, it specifically said 20, and then in 2001, it changed to allow the commission. And so by rule, the commission chose $20 a month. I would tell you, we would be highly frowned upon if we changed that rule to increase.
The commission, not the board.
No, the board. Sorry, we use the commission board.
So why is that frowned upon?
They're just not liking fee increases right now.
The governor has said we're not jacking up on that.
Okay.
To
That's
them,
all I needed to know.
them, it also looks like we're prohibiting people from coming in when we start increasing, any type of fee that we have.
Even the late fees.
Yeah.
Okay.
That includes penalties as well.
Interesting.
So,
Touched on earlier.
yep, it's been a.
Glenn, the question I'd have for you, of the 89, do you have any knowledge of how many are PDH lacking versus dollar lacking?
I don't have that figure.
I would think it'd be heavier dollar than it would
There's
be
a lot
PDH.
of inactive renewals
Okay.
that they've not paid their
Retired. Those would be retired.
Right. Well, the inactive.
No, we actually
We call them
have an inactive and a retired.
Right, but the retired doesn't have to pay.
Right.
But the inactive one.
What's the current number of total licensees?
Right. Oh, Jamie, what's that? It's like, we gave that not too long ago. Let me think about it. It's 1,700 roughly, somewhere in that.
It was 11:30. It was 11:31 back about the first of the month.
I'm gonna have to pull up the presentation.
That was how
You got too many
many-
boards going on there.
Yeah, you can tell,
There's
can't
about
you?
Well, I remember some of them was, maybe it was I inverted the number with Tennessee, because it was like, we asked for how many Tennessee applicants out of that number, and that was.
That was
somewhere-
8 something.
Yeah, and I was thinking that was 800 or 700, and I think I
Yeah.
put the two together. Yeah. Well, no, it was less than that.
1,100 and something.
1,100, I think.
Trust me.
I renewed 1,100.
It's in our minutes. I can bring that back for you. It's not a problem. If you, I can. bring it
That's a
back.
number that I like to know each time we meet, because we only meet, every 3
Mm-hmm.
months. It's good to keep track of that number. The number that total number we have and the total number that have passed the exam. Those are numbers, in my mind, that we should get from the director each time we meet.
Yeah, that's
For
no
general
problem.
knowledge.
Yeah, no, that's no problem. There's but yeah, I think Tennessee specific, that was about 800 something. But yeah, it's in our minutes. I'll pull it up. It's
8 something and 3 something, I
Yeah.
think's the way it breaks down
We can
right
get
off the
there.
top of my head. Okay.
Great. Application process, approvals, denials, deferrals. Basically, what we do at the end of our board meeting, and you're very familiar with that. I wrote down some notes just to kind of bring it to some sort of organization, and just kind of, I think, inculcate that, memorialize that as well. But basically, the process is like this. And for the benefit of our new member as well, we'll just go through that. Applications are reviewed via shared site. So that's WinSep right now. We've talked about some other sites, but it's WinSep right now. We're using that. 2 members must approve for an applicant to be put to test. If one defers, it goes to a third member. And if that member approves, well, we got our 2, we're good. If 2 defer, it's presented at the meeting. Okay. 1 deferral and 2 approvals mean the applicant has approved the test based on the statute. So we're good there. We already talked about that. A denial with the explanation will likely receive a second denial. Board's pretty on par for the most part. I mean, there's typically, if there's a denial, there's a pretty good reason that's acknowledged by all. Historically, we've seen that it's followed quickly on the heels of that by a second denial. We don't typically run in a situation where there's an approval and a denial. But even that would come to the board because we got a denial. So, if you've got your two approvals, we're good. 2 deferrals or 1 denial in there somewhere, and then it comes before the board. So that's kind of where we're at right now, where we fell. That's all I had as far as the updates, informational purposes at least.
Let me just expand on one thing. I did have a conversation with Jamie a little bit earlier. Of course, we, as the board members, we received notification that there are some applications available for us to review. We go on the website, download, et cetera, et cetera. I asked her more of a personal favor for me, just because of the way I'm warped and structured. I asked her to provide somewhat of a deadline. If I could get these back by Friday or get them back by May 15th or whatever. Because the way I work, if they're in a deadline, it's kind of moved to the second pile, and then if it's 15 minutes later, I've forgotten all about it. So I did ask her to do that, so I'm kind of more information for y'all when you receive your emails. You may see on there, Jamie working with me here, a specific date to get those back. I hope that's not an inconvenience for you, but it's just the way I'm structured. So it's more of a trying to get me to get the work done as opposed to anything. Help me out with that. I hope that's not too much of an inconvenience there for.
I have a question about that. As a public member, do I even have any authority to review or deny those at all? I didn't think I did.
I don't remember.
I think it does, yeah. I believe he does.
I served
And
before the
I say
public
yes
member
because-
went
I
through
actually
that.
think I think you do.
But we were reviewing them then as a group.
That's right. That's right.
We were able, and the other thing was, we were able to teach a lot of things to the public member as we did them. And the last I guess 2 public members ago, or somewhere in there, 2 public members ago, she had been on the board for 2 terms, and she was very versed in applications. And she, short of the plats and the legals, she was really very good in it. But it took a long time for Sue to get there, and she got there.
Yep.
And I'm not being disrespectful to you, Jed, any whatsoever, because I know everything that we're going to do for a while is going to be, brand fire
you're right.
new to you.
You're right.
Just like this new baby's going to be new.
You're not wrong about that either.
Let me double check into that, and I'll give you a hard, fast answer. So,
I think historically, there's I do remember our former public member would participate, but it was because Mr. Northcutt was assisting in that process. So, yeah, that'll be interesting. I look forward to the results of that.
I believe, just off recollection, that members of the board review the applications, and he's every bit a member as any one of us.
That's kind of, I
So
think it
believe
says
is,
members of the board, so.
So, yeah, absolutely.
So good luck.
Careful what you ask for. You might have just gotten it. Well, obviously, we do want to get an answer on that. If we can get that, maybe when we reconvene later on. After
0820-1.02 application says, if two or more board members
you go.
recommend examination of an applicant, such application will be required.
There it is.
Question?
Okay, so that may change things, a few things administratively, as far as Jamie, who receives the applications and everything. I assume, understanding briefly on the surface of it, that all four of us should be.
And I want Jed to have shorter timelines than any of us.
Yes. And maybe
So
right
he has to stay
around,
up late at night, so he'll be in prepared.
what did you say that
for
due
his
date
baby.
was? August 9th, somewhere in there? Make
I'm
sure
not
we hit
talking
that
to y'all
deadline.
He's going to be up anyway, right? He could be looking at some
He'll be
plans.
up anyway, so I'll have something to do, Jed.
That's right.
That's right.
That's right.
A little light reading? Absolutely.
I did this because.
Yeah, really.
All right. I think we're ready for new business then.
Great.
We do have just a sample plat, just one here. We were talking about, I know, Jay, you were discussing that about providing just a sample plat for the website, just to assist in the application reviews.
Yep.
And so, to that regard, we thank you for your submission there.
Certainly.
I didn't have anything really to add unless you
It's
want to
not
jump in
already
there.
on the website. We approved it last board meeting, and it was supposed to went on.
It should be, I believe so. Yeah, I was just covering from our last minutes. You're right. That's correct.
Just one little point of clarification. The purpose of this is for the applicant. In the process of reviewing plats that we get for the TS exam, each applicant submits 2 plats based on the Tennessee standards, and that I believe has produced a little bit of confusion especially from the out-of-state applicants. Right. Just as an example, let's say somebody from Illinois wants to become a Tennessee licensed surveyor. They have to follow the same rules, submitting the 2 plats for examples. Oftentimes, in fact, most often, I would say, the out-of-state applicant would submit 2 of his work products that generally were in compliance with their state specifics, in this case, Illinois. However, the instructions specifically say that the plats that are to be submitted are by Tennessee standards. And so oftentimes, we as a board, as we were reviewing the plats, we'd find many things on these plats that were not in accordance with Tennessee, and we would either deny or defer that applicant because they weren't in Tennessee standards. So because it was happening over and over again, we collectively as a board thought, let's put an example on the website, something that more along the lines of what we're requesting in terms of plats. One of the specifics that we were requesting was simplification. Many of the plats submitted were these very elaborate, very detailed, outstanding looking surveys, but way more than what we just need you to do, or what we're asking you to do. So that was the purpose behind this sample plat that I've submitted here. Hopefully, if it's not already, we can get it on the website earlier for those applicants. So that was my part on that.
I did. I listened to the last board meeting, and that was the instruction, and so I have no doubt that's already there. But nonetheless, that was the plat, and I don't think there was, like you said, anything else necessarily discussed. But let us know it's there and it's doing what it's supposed to do.
And I think also there may have been a bit of confusion about the GPS rules that went into effect yesterday, I think it was. Yes. I think they had received some requests for an example plat showing the GPS rules. I think or maybe we as a board or administratively may have misunderstood what I had proposed submitting in a previous meeting, and that was an example of the new notation that's going to be required on a survey that involves GPS. I think there was 5 or 7 different metadata type items that were to be filled in. And I have not submitted that yet because I'm letting the waters calm. Of course, we went through the whole process twice over. There was a lot of questions still coming in. We wanted to kind of get all that settled first, as opposed to submitting an example and then there's a misunderstanding or something changes, pull it off and then put it back on. I did not want that to happen. So now obviously the rules are in effect. The waters have settled. In fact, they're dead calm now. It's in. So that example will be coming very soon. You'll get that very soon. from me.
Perfect. If you just send that to us, then we will blind copy it to all members and just ask for you to write back and say that you're okay with it. And then once we get that, we'll go ahead and get it online,
Okay.
so we don't have to wait till the next meeting.
Great, because I know many of the registrants out there are anxious to get this done. I myself have received emails from local surveyors asking the exact same question, and my answer to them has been, we're going to discuss it here at the meeting.
Absolutely. Thank you.
You'll be hearing from me. Okay, Glenn, anything further we want to cover under new business with the example plat and the GPS rules?
No, sir, that was it.
Any other item? Oh, go ahead.
I have a suggestion, request, inquiry, or whatever. As we sat this morning going through the legal reviews, and we kept referring to our statutes, and some of us don't always remember to bring them, and our new member doesn't have them. Could we get these in a PDF format?
Yeah, we
So-
should be able to, I'll send them to Glenn in PDF format so that he can have them, so that they're on the iPads every
Yeah,
time.
we can do that. That's easy.
Yeah, we do it for the other boards, so we can
Sure.
make sure that's done.
Yeah, very well.
Good idea.
Mr. Chair, and I have a question as well.
Certainly.
When we crafted the new rules for professional conduct, in those rules, it stipulates that all firms are to register with this board that are surveying in the state. My question either to Glenn or Jamie, or both, is that happening? And if it is happening, how many have we got? And if it's not happening, then we need to see that it does happen because it is in our rules.
Do you recall how often a firm has to register? Is it only one time? Is it annually? Do we
Tim, can you give me that rule site?
have it out, Tom? I believe the form for doing so is on the website. I have seen it recently. Yes, I believe that's what you're referring to.
Yes, that's correct.
I know that is on the website, so it is available. I just don't off the top of my head recall if there is a recurrence of that registration or if it's a one-time. I just don't recall. which one it is.
0820-04-.10.
I'm like you. I've seen the firm disclosures, and I have. We've had some of those submitted. So is that what you're referring to?
Yes, sir. Yes,
Okay.
sir.
Okay.
I just kind of felt like that sort of slipped in the cracks once we got that actually approved and it became the new. And I think that's something, as part of our board's responsibility, is to notify the registrants and say, hey, look, you might not have read this, you maybe didn't pay attention to it. However, by this particular rule, it says that you need to do this. And I think in the spirit of your question, Ms. Sarah, is I think it's a one-time thing until you change.
It's a one-time thing until there's any change, and then
Right.
you have 60 days to notify us of
Right.
that change.
Right.
So,
The change
I
being,
give them every time
Change being
they
a
apply.
new licensee in an office or a new licensee as owner
You
or
change
a
of
change of
status
address,
or-
any
yeah.
kind of status change. It's a very simple thing, and, we do not have a fee for it, but it's something that is required by the rules.
I get that for every new applicant.
Okay.
We've had some hardy discussions
check in
about
on
that
that,
before.
yeah.
We've had some hardy discussions about that before, Jamie. Now, not about the absence of, but about those that were disclosed to us, and to make sure that they were in compliance in that regard. So, yeah, that's hasn't escaped the radar, at least in that regard. So, I want to give you some assurance on that front. We haven't forgot about that link on our website, so we're good there.
Well, in many other states, I can give Kentucky as an example. I know Jackie knows this, that, you have a firm registration, and they actually issue a firm number.
Permit.
And then if you don't have that permit and you're practicing there, then, that's a disciplinary situation.
Tennessee is one of the few states that doesn't have that.
Right,
That-
and
that
that
I'm
was
familiar
one
with.
reason we put it, I wanted to put that in the rules of professional conduct when we did, knowing full well that we couldn't create any new fees, any new things at that time with the legislature. But I wanted to set the foundation for that as time went on, so it would be easier to transition into what some of the other states do if we could get to that point.
perfect.
Any other additions to new business here? All right. We're under application reviews. Is there anything we need to do
We
here?
left that just in case we had some that were deferred, but we have, some in the pipeline, but nothing deferred for the board, so nothing in that regard.
So we're clear on that for
Yes,
now?
sir.
Okay, all right.
Are you pretty well up to date then with applications, Miss Jamie?
I'm still, I'm missing pieces.
Okay, all right. Is there anything that we can do while we're here in terms of the application reviews that would help you out? No, okay.
They're not paper, so,
All right, with that, I think we've concluded the items for business under the 9 o'clock session. Of course, we will be convening again at 1 o'clock, I believe, over in the other room.
That's correct, yes, sir.
With the
I
A&E.
thought we were going to meet in here and then go back. Did that change?
No, we're going to be we're going to be over there. They've got two things going. They've got I believe it's called a work group or a work session. That's going to be after your joint meeting. So that's all the movement that you're probably referring to. But the 1 o'clock with you folks is going to be in the 1A. So right up next door, we're
I
going
thought
to.
Roxanne said this morning that they were coming over here, the
Well,
engineering committee,
figure it
and then we were going over there at 2 o'clock.
Yeah, that's
How
fine.
about we meet in the hallway in between?
That works for me.
Well, at least we're not so far away that we can't figure it out. You know, they're right now.
It's a long walk.
We'll have a conversation about it if we need to. But
Can you bring us a little push cart or something, Glenn?
I have a feeling we're going to connect if we're all here at
Oh, okay.
once. So I think we're probably pretty good stead there.
Okay, with that being said, I think we've accomplished the items on the agenda for the 9 o'clock block. We'll go ahead and break here for lunch with the understanding that the next meeting will kick up at 1 o'clock sharp, either here or there. One or the other.
Somewhere.
Somewhere.
That's right.
Somewhere. We'll be somewhere. It's 5 o'clock somewhere right now.
Somewhere. Okay. We're back here from a brief lunch break there. We're going to kind of change channels a little bit here. This is a little unusual for this board, at least in relation to the normal standard procedure of a meeting, if there is such a thing. But we extended an invitation. They gratefully accepted a few members of the A&E board, what we consider kind of a brother-sister relationship here. We're very close. We have very similar aspects among us, and in the same manner, a couple of differences as well. But certainly in our professional lives, we deal with each other quite a bit, and just by natural progression there, the two boards do have a lot of things in common. And today's just kind of an open roundtable for items just to kind of throw out there, have a general discussion. Obviously, no decisions are going to be made here on the board level, no motions accepted. Just kind of throw some ideas back. We've got a couple items listed on our agenda. I'm sure you all may have a couple things you want to throw in there with us. But obviously, one of the topics that is certainly of interest to both these boards here recently is the idea of QBS. And I thought we'd go ahead and just kind of start that off. I know you all have another meeting at 2 o'clock, I think it is, dealing specifically with that. So I kind of wanted to throw that out front here and just kind of see if we can find some common ground. And kind of, I know you all have had some recent interaction on the QBS. We kind of wanted to see where that was going, all in the interest of perhaps one day surveyors also being included in QBS. So with that, I'm just going to kind of sit back and open the mic and let the questions be presented, and we'll see where it goes from that. Tim, I know you had some interest in the QBS and where the engineers were going with it now. Is there anything you wanted to throw out on the table, Adam, and just kind of see how they developed to where they are?
Well, I know y'all still having discussions and going to have some this afternoon. Are y'all looking to modify the current statute that you have, or what direction are y'all looking? Are you just listening? Because there's others.
And we're recording just that.
Oh, we
way.
are recording?
Yes,
Okay, I
yes.
thought this was informal, I'm sorry. Our designated spokesperson is sitting right over here, Robert Campbell, so. I will remind you, we're recording.
It didn't turn red.
That's fine, I've cussed before. Do you want me to say anything?
Sure do. I think all of us probably will.
So QBS is obviously under the Brooks Act, which is a federal statute, and I think surveying is not included under that statute. It is.
Federally,
Federally it is. Okay,
Yes,
I
sir.
couldn't remember. I knew there was a photogrammetry at one time. So there was something that wasn't, and I couldn't remember what that was. Okay, so you're included under that statute. Then it's just a matter of, if you're included in that, do you have legislation? Any kind of federal money, it seems that you all would be under the same QBS statute. I don't see how you can get out away from that. So you're included.
We are on federal.
On the federal
It's a
level.
state level.
It's a state level. So again, that's part of the discussion is the state of Tennessee's got what they call the Mini Brooks Act, which that's what you are excluded from then. And it's just, it would be a legislative thing to get you included, number one. Number two, as part of this discussion that we're having today, I don't know what modifications are going to be suggested by other groups to this. We know that the process has been effective at eliminating unqualified people, but it's also cumbersome. And your profession, frankly, is going to have to decide if they want to go fight the fight to get included and want to have that amount of scrutiny. And then you all as a board have to be prepared to, or as a profession, have to be prepared to go after people that are violating a state and or federal thing. And, a lot of times we end up being our own worst enemy. That's what we did. What was it, about 4 years ago? Does that sound right?
2013, right?
Enacted in our rules that if a registrant put in price that they were in violation of our board. Of course, that's all been, we're discussing that again this afternoon, but we took the step that we needed to police our registrants, and surveyors have just not been used to that, so it's culturally going to be different, and it's going to be something that I think a lot of your all's board, TAPS, and others are going to have to really invest a lot of time and energy into getting that.
Robert, before you came in, Tim was saying that he'd gone to the Attorney General to ask for an opinion as to whether or not surveying should be included in the QBS process, and I didn't get to ask.
Not to be included, was included as it was written.
Okay, and
I think he may have been referring to what you are, that was passed in 2013.
That was just with our board. That was not a legislative.
Yeah,
that was not a state. No, that was not a legislative.
Yeah, what I was curious about was if the definition or breadth of who they included originally in QBS, if we could be included. That was basically the question that we asked. And the response was, the way it was written, he did not see that we were inclusive. So that told us automatically that we were basically out of that particular law or statute.
So it's a legislative change for you.
Right. And that's part of why this joint discussion is, because, I'm all about efficiency, and if the efficiency of a change in a QBS statute could be and include and not encumber the direction you all are going. In other words, if it said architects, engineers, surveyors, contractors, funeral home directors, whoever, whatever it said, and that would not deter from the mission that you all are setting forth, then to me, that is a more simplistic way of dealing with the law, as opposed to having, okay, here's an engineer's QBS, here's an architect's QBS, here's a surveyor's QBS.
And I may be ignorant of an effort going on, whatever, but I have not heard that we're trying to change a statute. The statute's there that provides for QBS. What happened in 2013 was just on a board level. It said we're going to enforce that statute by discipline against registrants if they give a fee. The recent issue has been that when that happened in 2013, we started getting a lot of questions from registrants and also from government bodies who hire engineers and architects. They didn't want to get in trouble. So, but there were, as you can imagine, statute doesn't cover every instance. So we had the FAQs on the website specifically for QBS that dealt with all the questions that had come up and the way that was being interpreted. And that was seen as within the last year or so, as a legal challenge or something legally that that was a problem, so that was pulled off the website. And so now I think there's discussion. Part of today is to get things back on the website, to offer those interpretations to help people both accomplish, what the goal of the statute is, stay out of trouble, however you want to look at it, as a help. So that's really the issue that I'm seeing we're dealing with as a board right now, the present day issue.
So you're going to have to do a statute, the Tennessee Code annotated change, right? I mean, what we're doing today, what we will be doing, is not going to go impact the statute. I mean, it's going to be, but we are developing probably, I think the right way to say it is a policy, or more defined policy around that statute is what I would classify what we're doing today. So you not being included, I mean, there's no piggybacking onto the effort. It would have to, part would have to be done first, because I don't think we're seeking to change.
And the QBS, as it applies to your board, is basically for state-funded projects, correct? Or is it for all publicly funded projects, whether it be municipality funded or state funded?
Utility districts, state offices.
Okay.
Yeah.
Okay. So it's very broad reaching.
It is.
Okay.
For Sarah, real quick, if we had mentioned some best opportunity for the legislative sessions, was that?
Legislative proposals will go up at our next meeting. Yep. I believe our July. Yeah.
July. Okay.
26th. Are there current hurdles? I know you spoke about the encumbrances of things difficult. Do you see a lot of hurdles at the smaller county municipality level? Is that where most of them are more troublesome, I guess? No?
No, it's troublesome at every
location.
No, I mean, it is, and there's some that get it and understand the value of quality-based selection. There's some that only look in front and see a low price, and that can happen at the largest municipality in the state of Tennessee, or it can happen at the smallest county local level that you see. Again, some get it. I mean, most do, I think. And part of what we were doing, that education effort, was really paying off because you saw a lot of people go, okay, we understand why. But, it's the old thing where when you have to go in front of a county commission, a city council, and you've got $100,000 budgeted, you try your best to stay within that $100,000 budget so that you don't have to explain why this, and this happened. And, they're very much driven by budgets, not necessarily by the value of or the legacy of the project, the legacy costs, the value that qualification-based selection brings to a project. And understand why. I mean, that's not a condemnation. It's just, it is what it is.
The best methods of educating all the public entities at the time that the QBS came into effect. What was the best way to educate them?
Used to be referring them to our website.
Right.
Yeah.
Even before then, it was we tried to get, there was a lot of reaching out to, here's why qualification-based selection is important. And it was a kind of and Kathy, it was more of a grassroots, let's go sit down face-to-face with the county mayor, or let's go sit down face-to-face with a purchasing, and here's what the statute says, here's why it's important. And so it was really a member-led thing, I think, and, organization-led, where we were talking to people about why it was important and really trying to, I don't want to say marketing because that's a little too slick of a term. It was really a face-to-face kind of thing. Because Kathy was in the middle of it when we passed it in Tennessee. That was in so she.
Yeah, I would tell you the biggest hurdle that we faced as an industry is the fact that people come and go at every level of government, and spend a lot of time educating a small town purchasing organization or a purchasing organization the size of Metro Nashville. But people retire, people move on, people are elected, people are defeated when they rerun. There's just constant change, and it is not an easy subject to educate people on, nor is it at all easy to be consistent. And so the FAQ, from my perspective, and we've had many, many discussions for 2 years now on it, was that attempt to try to be consistent in the answers to the questions that came up most often. And I would just tell you, you're just going to be educating from now until the cows come home, forever. You will not do a single issue education campaign, and you won't do one mailing, and you won't have one conversation. But if you want to be a part of it, then it will just require that your membership and your professional organizations and the people who are out there trying to make a living and do the right thing will be constantly educating their client base and the public at large, and you'll never stop.
Got a question just for your work. I know that a lot of the surveyors do work for either engineers or developers, maybe, I'm not sure, or private landowners. How much of your work is with public entities?
Probably the answer to that probably be the dynamics of the firm itself. Tim, you work for a surveying firm specific only. I would imagine that the answer is who work for AE firms.
Right.
So, from my perspective in the Memphis area, I work for predominantly a large engineering firm that offers surveying, kind of much like a secondary service, so to speak. So, most cases, we're already under the QBS umbrella in terms of we're offering the service predominantly as an engineering service. And along with
you're
that
like
comes
a
the
support service
support.
to
Right.
the engineering service.
Exactly.
Like your firm's being hired to provide engineering services. Will you also, as an incidental to that, y'all provide the surveying?
That's many cases. Now, separately from that, we do also have surveying-only specific contracts, one of which is with the state. That is, usually it's several firms submit fees, and they select specifically on surveying. And it's my understanding that does not fall under the QBS umbrella. Rather, it's from best I can tell, it's a low bid type situation. And so I think those are kind of the specific projects that we're looking at in terms of those should fall under the QBS umbrella as well. For whether I'm working for Board of Regents who will come through and do a bunch of improvements to the university, and they need a surveyor, they'll hire the surveyor separately from the architect. Or if it's another state agency, Department of Finance, Parks, you do Parks.
Finance Administration.
Finance Administration. So there's several opportunities as a surveying-only entity, whether you're wrapped up in an AE firm like Jackie and myself are, or as an independent surveyor, surveying-only firm. So there's lots of opportunities out there for state-funded, public-funded type entities to hire specific surveying that I think would be better served in a QBS umbrella.
All on Alton's point, we've talked about it in the last 2 or 3 years about sub-consultants. Do they fall under the QBS? And we're a mechanical electrical firm, so more often than not, we're working for an architect. Not always. And I can't quite recall whether we were talking about just interpretation of the statute as it reads now. Do we interpret it that it applies to subconsultants, or are we talking about changing it? I think we were talking about just interpreting. How do you interpret it? And I think there was a recognition that as far as the need for QBS, the same rationale exists. If you select an architect by QBS and then you select all the engineers on a low bid situation, it can still hurt the state or the public entity, whatever. But there was a limit contractually and legally. It gets really messy when you get into those sub-levels as far as trying to control that or dictate. So the bottom line is the board felt like in the past discussions of the QBS law dealt only with the prime.
So Liz said I was allowed to talk because this is informal. I'm Casey Anderson. I'm the executive director for ACEC and TSB. I was here last year with y'all. I'm going to throw out a little bit of caution in terms of your timing of all of this. We are about to have an enormous overhaul across the street. The House is going to be at least a third, confirmed at least a third flipped. We're going to have a new administration, new governor all the way down, probably new level people across there. We're going to have to do a tremendous amount of education on what QBS is already. And depending on how, I would just caution you about diving in June on a decision like that, because what you don't want is to shoot the whole thing in the foot coming, you know what I mean? Like, we're not going to know the lay of the land by any stretch. And I will tell you right now that we had a bill this year that we put under a procurement, we kept it in a different section of the code specifically because we didn't want to open up the opportunity we didn't want the QBS for anybody, because once it's open and anybody can do anything they please with it. So I would just caution you to think through the process, because it's not going to be an easy lift. Thanks.
Words there, good words. Well, we've still got to garner the support of TAPS, although it's had discussions. It seems to come and go. Local level. And honestly, in my opinion, in order to get this thing to go anywhere, it's going to need the support, not only the obviously the timing has to be right, and I think we were just advised that that's probably a good precaution to take care of is the timing of something like that. So we're going to have to do a little bit of homework with it as well. But all good points, excellent points.
Let me go back to something else. If I understand what you were saying, most of your solicitations, again, like we discussed, are through engineers. How much work, mostly through engineers or developers or private entities. When you go to a public entity, it's mostly the state of Tennessee. How much do you do in counties and cities where they come directly to you?
It depends.
Outside of them, outside of you being in a firm that's doing engineering service, they just come to you and say, "Can you give me a survey for doing this?"
Yeah. I can only speak for the county that I predominantly work in, Shelby County. We have a contract with the county and also with the city, specifically for surveying services. Now they will have, I don't know how many they have, but 4 or 5 different firms, surveying offering firms on their list that have gone through, the initial
qualification process.
Some sort of qualification process. And then from that, 4 or 5 are selected, and then as projects come through at their discretion, they divvy them out. I'm sure they have a process I'm not familiar with. So, depending on the workload and the time of year, things like that, you might get, 1 a month, you might get 1 a year, you might not even get a phone call. Yeah. It's just, in the entity that you're working with. But, I find that in both the city entity and county entity.
I know for us, Robert and I, not so much Kathy or Ricky, and again, Steve works for a governmental entity, but for Robert and I, at least, we work for a lot of cities and counties and utility districts. And for them, one of the things that was important for us is that the counties have the CTAS, the County Technical Advisory Service, and then there's the Municipal Technical Advisory Service for the city side, and then the Tennessee Association of Utility Districts for them. And once you make them aware of what the law actually says, for the most part, they all have lawyers on staff, and so it's a pretty easy process for us through them. Now, the state also has lawyers on staff. The difference is we do have the enabling legislation, and I guess at this point, what you've said, Tim, is you're not included in that QBS.
What is the enforcement? How do y'all handle enforcement? If you find a request that's come out there and it should be under the QBS umbrella, but it's not, how do you either suggest people handle something like that, or how does that handled?
That's actually happened to me, and I will tell you how I've done it in the past is if we get a request for proposals or a request for a statement of qualifications and they want us to provide a price, I mean, one of the first things I'll do, and this sort of precedes Casey, but I'd call the executive director of TSPE and say, look, here's what we've got. I'm going to send this, I'm going to scan it and email it to you. Can you please make contact with them and make them aware that they can't do this, or engineers actually can't submit this way, and refer them to the website if they need to. Well, it's not on the website anymore, but the director knows very clearly and understands and has all of the information at hand to be able to provide them the qualification-based selection process and the law, and can refer them to, if it's a city that does it, MTAS, and MTAS is legal counsel, or CTAS on the county side and their legal counsel. So ours is fairly straightforward. That doesn't mean that doesn't mean that they don't ignore that and just do it.
My next question, yeah. How effective is it?
Some, it does have an impact, and probably, I don't know, Robert, I'm talking about my experiences. His may be different, but I'm going to say probably 75 or 80% of the time they'll reissue the request for proposals and take the price. They'll do one of two things. They'll either take the price out of it, or they'll ask you to put the price in a sealed envelope. But I will tell you this, if you put a price in there, that's what they're going to look at. They're going to ignore everything else. They're going to open that envelope and see who gave them the lowest bid, and they still refer to it as a bid. And Sarah did that today too. I meant to talk to her about that after the meeting, but she didn't call it a bid. So
Other Sarah.
the education is our Sarah.
The other lawyer, Sarah.
The other lawyer, Sarah. So the education process is ongoing.
As I understand, the enforcement is not against the municipality.
No.
It's against the engineer that submits a price.
Yes.
Really? Yeah.
It is now.
For us,
Now.
yeah.
It is
You're looking
now, but, and I'll let Casey talk after this. What you have to understand is there is a enforcement against the municipality, and it's called litigation. Okay, I mean, there's not and that's what we're trying to talk about in this next meeting and try to get worked out is, technically, I suppose, if a municipality violated state law, they can be sued, but you have to go to the expense to do that, and nobody wants to do that. So,
At the probable loss of that,
and so those things kind of go unresolved because the cost to bring a suit against a municipality is going to be fairly expensive. So go ahead, Amy.
I was just going to say that I send a lot of letters, and as do other states around the country, like sort of all of, in my state directors of ACEC, we talk about this a lot. And in the last year, we looked at it about 6 months ago. We were about 90% effective on those. Majority of municipalities literally don't know better. There was one we had last year. It was an ADA compliance. They had no email in this county. They had, here's your letter in the snail mail, and said, "Can you rewrite it for me?" I said, "Well, I don't think that's appropriate, but I can guide you a little bit. But it really, for most of them at the municipality level, a lot of it is education. And I think it probably is across the board. What happens in the bigger agencies, particularly our biggest agencies, is when an RFP, because it's usually written as an RFP and it should be an RFQ, when you're in a big enough place that ends up with the procurement people, the procurement staff is used to very strict rules on how they take commoditized, how are we going to buy these pencils tomorrow? And this is so out of the realm of their piece. And so a lot of times it's just making sure that the right person in the department sort of knows the drill. I've spent a lot of time with attorneys, talking to attorneys about things, but the letters in general are very effective, because what we're saying is, what I think the misconception, they think that if they're asking for a price that they're going to get more people to be interested. And what in fact happens is that they shrink their pool of people who are interested and of their options. And when you look at it like that, my letter is very general, and it's to stay away from any kind of antitrust or whatever. Nobody ever knows. If every one of them called me about the same thing, they wouldn't know each other. It called me, the people I'm talking to don't ever know. So it sort of puts this wall up. But there's something to be said for the people who might be perfect for this project are not. They don't feel that they can comply with their own registrant rules if they do. And here's how, you either fix that, you can either pull this and put it out a whole new RFQ, or just amend it, put an addendum out that takes out, and I'll say that takes out this specific place. It's effective majority of the time.
As far as enforcement goes with the registrants, how often do y'all have complaints filed, or how often do you bring about a complaint against a registrant for this kind of violation? And what are your options as far as any disciplinary action that you can take? And
my memory serves me, we had a case or two at the very beginning when we did that. But really what it did, and it served a great effect of it, let us educate our registrants on what they couldn't do. And so they didn't in most cases. I mean, I'm sure there's always a case out there that we don't know about, but I think we had a case or two that came to us in the very beginning of when we did that rule. But for the most part, we were able, when they saw the rule, that generated a lot of questions back to your all's office. It generated questions to our board members about, you mean we can't do this, we can't do that. And our registrants, by and large, whenever they saw one of those things, would contact Casey or whoever and say, hey, this RFQ's on the street. Can we, help us educate the person doing it? So our registrants really, except for that first one or two, and I don't know how many there were, right? It may have been more, but didn't get entangled in any of that because they saw the rule. The rule was an effective deterrent for them to, go out and violate the law, which the law, that is the law. The Tennessee Code Annotated is the law.
And the audience that we're talking to is engineers. We're really not talking to the public. So, and I will say too, I think that
an architect
and architects, obviously, yep. Yeah. But the previous administration had done a good job during that time frame of going out to TSPE meetings, ACEC meetings, ASCE meetings, etc., AIA meetings, and explaining that to registrants. Hey, you can't do this. Here's why. Here's what the law says. And I think there was an awareness program early on that helped that a lot.
I kind of remember first couple of cases right after 2013 where there was leniency because this new stance on it had just happened, and so and that seems like maybe all it took to get everybody on board. But there was, I think, a grace period there.
Are you finding the QBS is accepted by most of the other states as well? I mean, would it be an exception to have it or to not have it?
An exception not to have it.
Really?
Mm-hmm.
I know I got involved with ACEC Memphis chapter, I don't know how long ago it was, 12 or 15 years ago. And QPS was absolutely drilled into my brain, every meeting, every written thing that came across. So it's not anything new, and that kind of told me that came from really national organizations. So that it's not just Tennessee.
Let me give you another thing too, and this is on the same topic, but I'll give you the part of the dark side of QBS. Understand that qualifications-based selection, you have to supply qualifications on some level. Okay, those qualifications then get reviewed by people who may not be technical in nature that are doing the review. And so you may have the best surveying, you may be most locally, you may be the right choice. And today the purchasing agent knows that, or whoever, the assistant director of engineering knows that, and knows that you've done 100 of those before. You've been, you're 5 minutes from where this project is. It just makes sense to call you all up and do the job, right? I mean, QBS potentially puts you in a different thing. It puts you in now you're out of West Tennessee, and I at East Tennessee see an RFQ go out, and I put in my name, and my qualifications may be not as good as yours, but I do a pretty good job of writing a proposal, okay? And the people reviewing that application are your purchasing agent, somebody they got from wherever, and somebody that kind of knows what they're doing. But my proposal looks really, really good. And so those other two people that don't know what you're doing are going to score my proposal really high and score yours lower. But I've got 2/3 of the vote. I get the contract. You don't. So I just want you to understand that I know I applaud you for I think there needs to be a desire to get surveyors, and I'm going to use the word more professional. That's not, but you understand what I'm saying. I've followed behind too many people that have done window surveys, and trust me, okay. And so I understand that your profession deserves and needs, and it's how I cut my teeth to get moved up. But in moving up, there's another set of things that the QBS world can hamper you, and I think I'm stating that correctly.
Robert, you remember Jack Flint, and you probably knew Jack Flint too. But years ago, Jack did a lot of work for the city of Knoxville, and I had to sit down with him and explain that you just couldn't put together a RFQ anymore in black and white. Because exactly what you're saying, there's too many people that are in the review process and rating it that you got to make it pop a little bit. But Jack didn't appreciate that. But that what you're saying is true. There are in the larger cities and counties, you have non-technical people making technical decisions about consultants, and engineers don't care a lot about color. We can read your qualifications and what you've done, your past projects, but others don't do so well at that. Yeah.
Oh, yeah, and it's everywhere. You're right.
Yeah.
It is everywhere. But so again, I think what you're trying to do is the right thing. I think how you can guarantee the public that they're getting a service that they're paying for, and it's a quality service. Because we all know that just like all PEs are not equal, all RLSs are not equal. And there's some that can do some things and some that can't do, some that couldn't solve a boundary if the law cosigns was put in their, imprinted on their forehead. So I brought up a little surveying terminology in here.
He's trying.
I'm impressed with you, Mr. Campbell.
I'll talk some more of that stuff if you want me
Yeah,
to.
you talking some good trash there. I like
Buddy,
that.
I can talk about brush hooks
Yeah, I
and
know
total
it.
stations
I know it.
with the
I know
best
it.
of them.
You probably had a case to a poison ivy too, haven't you?
I've had a few encounters with
I
rattlesnakes as
understand.
well.
There you go. Well, I think it's a very productive discussion, and from where I sit, I'm a small surveying firm owner, and I've been fortunate to be part of quite a few RFQs with engineers and architects, building teams for municipalities for specific projects and things of that nature. And that kind of is what spurred my interest into this particular subject matter. But I think, Robert, you said it best earlier, in a very polite way. You mentioned surveyors and professionalism, and I think that QBS offers an opportunity for my profession to step up to a new level and get away from the things that you all have seen in the engineering and architectural world for years ago of the good old boy network and those kind of things. And it's in my opinion that to be a true professional, you need to operate in that kind of environment, both in representation from yourself, your firm, but also in work product, proposal product, and performance, clearly performance. So that's really why that I'm interested. And I think that, as in anything, you have to have folks that are interested in different ideals and concepts that may not exist or exist in some small form, but possibly should be a little bit larger form. And that's why I support QBS. And you've also mentioned some of the pitfalls, and you're exactly right. I've been part of teams that, the team was as strong as it got and finished last. But that's the nature of the beast. It's the nature of the beast. But the positive thing I can say about that, even being in that environment, is the fact that I know that all the players that were involved, for the most part, it was a pretty level field that was reviewed. So I think that's what I strive for each and every day in my business and in competing with other fellow professionals, is to be able to try to compete on as near a level playing ground as possible. Obviously, the fee that I charge and how I go about deriving that fee is going to be different for the next firm, next individual, et cetera, just like it is in your business. But on a given day and a given project, I think it's good to know that you have the ability to all enter the door the same way. So that's my 2 cents, and that's part of why I'm interested in it. And I just feel like it's something that's somewhat past due for my profession, and I think it's something that can be very positive for the profession.
Do we have any idea how many other states have QBS in regards to surveying?
I just looked it up.
Did you?
44.
In regards to surveying?
Mm-mm.
Oh, just
Engineering, yeah.
I know, was it Alabama a year or two ago that had an issue?
It's been in the last year. They're sorting through their stuff. What I'm happy to do, I'm going to be with at a national meeting with state execs from around the country, and QBS is on the agenda. I'm more than happy to do a quick little who's got surveying, because I think it's important for us to have the big picture. I'll be there Saturday, so
Yeah.
I'll try to gather that.
Yeah, that just helps make it easy when you get asked questions as we move forward with this, so that we can tell folks that, hey, look, we're not plowing new ground. It's already been broken. We're just, getting on board.
I will say that the issues that they have brought up are the exact same ones that every other state deals with, which is why it stays on our agenda at national meetings.
One of the other, I'm sorry, go ahead, Kathy.
I was just going to say, one of the things that I think can be a negative about competing in a QBS environment is that the cost of doing business is more expensive, and your client base is probably going to have sticker shock in 20 years if you convert to a lot of most of your business being QBS, because of the reasons that Robert brought up. When you submit a proposal and you have to compete, especially if you're a small business, if you're a small business that is competing against a much bigger business that has the resources of a business development department, 16 proposal coordinators, 5 business development vice presidents, and a graphics department. Your ability to compete with them, you've got to really bring your A game if you want to get selected, and therefore it costs a lot of money. And that's just a reality. It's not necessarily a negative. If you raise the game, raise the bar on everybody, that's good, right? But it's something to think about because you can't just do it on the back of a napkin.
Yeah, it's just like Alton mentioned that he and Bob do some utility work and so forth. I mean, everybody in the engineering profession, the civil or whatever, doesn't do utility. Same thing with surveyors. A lot of surveyors are not interested in working for municipalities and counties. All these rules and expectations, and you're right, it does cost more. It really does. There's no
Not in that environment. You don't necessarily have to incur that cost.
So, and I don't feel like that it's a small niche. I think there's enough of uniformity across the state that if we had the ability to do that, and that was the way we proposed public, and that's what I'm looking at is the public getting a fair shake? Just because somebody is the low price and then they do a sorry job, did the public win? Because somebody may have to come back and clean that mess up, and which means the public's going to have to pay more to get to where they should have got to the first round. So, that's the kind of thought process that I look at when you talk low bid. It's like I tell people all the time if they call and ask how much something might cost, I said, well, they make a comment of, well, so-and-so told me they could do it for this. Mm-hmm. And I said, well, all I can say to you is it's kind of like the guy changing oil. You get what you pay for. And that's just sort of my opinion.
To follow up on that, I think we need to remind ourselves, QBS does not mean that price is not part of the selection. Price absolutely is part of the selection. It's just the order of it.
Right.
If you select on qualifications and you go make your selection, then you negotiate. And if you're getting a price that is higher than you've paid for years for getting surveying, and you have 3 firms that are qualified you'd be happy with, move to number 2. So you can tell the public, I am looking at price. Right. We absolutely are negotiating. You're not just obligated to do business with your first selection on qualifications. So I think we need to remind ourselves price is absolutely part of the picture, and it becomes a really education for those hiring entities of how that process works. You're still looking out for those dollars as much as you ever are. You're just trying to get something worth it like you were talking about, that you're not going to have to come back and clean up. And we've had to come back and clean up. So I know how much that costs.
I think you hit it on the head. It's educating the people that are asking for the proposals, because apple looks like an apple, and if you can't, they're not technical enough to read through it to track the important things, then it gets down to the bottom dollar. It's frustrating on our part. Very.
I think the other thing I would add, and I think this would likely apply to you all as well, is one of the biggest reasons in my mind anyway, personally, for QBS is that the scope is always ill-defined. The reason that low bid works in construction is because you're saying how much for this. With what y'all are doing, it's sort of, it's a little more arbitrary. It's we want this, but it's sort of in the cloud, and we don't, and it's defining in there, what could come, and that the risk and the it absolutely, you can either have cheaper, faster, and the reality is, if you're missing the qualifications piece and you haven't scoped a project, you don't even know what you're in for. So I do think that piece of the scope issue, I think, would absolutely apply in your profession as well.
All great points. Great discussion here. Obviously, we've got some homework to do and some thought about proceeding through this. Yeah, thank you. We are getting close on the clock here to the 2 o'clock meeting. One thing I just wanted to bring up, something that's going on. I can't explain why down in my area. I've never had so many phone calls in a brief amount of time about this. I'm seeing a rash of surveys that are stamped by engineers. And I can't explain why. I don't know what it is.
That are not also RLS?
That are not all, yeah. And these are flat out labeled as, subdivisions or boundary surveys, and there is a, straight up an engineering stamp on it. Some of which have been recorded, which is, doesn't, I'm not trying to take the blame away from the engineer, but falls back a little bit on the recording agency there. But I didn't mean to bring it up for discussion of any kind here, but rather just as a point of view. I don't know if it's happening, if you're seeing it here. But something's going on in West Tennessee here that I'm receiving. I'm actually getting phone calls from surveyors saying, hey, here's something I found. What can we do about it?
Two quick comments. Number one, on the register situation, the registers of the state of Tennessee are held harmless about any document that they register, no matter if it's legal or illegal.
Right.
So that kind of takes that out of the equation a little bit. Secondly, on engineer stamping subdivisions, we still fight the battle with municipal planners, because in their regulations they say that surveyors or engineers can sign, so it does not conform to either of our laws. It should say the appropriate design professional at a minimum, but it does not, and we still fight that in my area. And when they revise their regulations, that's what I recommend to them, the appropriate design professional, because they do mention things that are required for a civil engineer to stamp, such as drainage, so forth and so on. That's part of the subdivision development process. But we as surveyors do not get a lot of help from other entities that we have to prepare things for, because they have language that is antiquated that allowed engineers to. Because as y'all know, in 1979 we passed a thing to grandfather engineers in that were surveying, and that put that to bed. Then engineers had to become surveyors from that point forward. So, I don't know why you're seeing that, Jay, other than maybe it might be a glitch in the planning thing.
I don't know.
Were they signing plats?
Yes. It's black and white.
With no surveyor.
Has anybody entered a complaint to the
that's
board?
what I've suggested to them, is to start the complaint process.
Yeah.
Whether they follow through with it or not, I don't know.
Yeah, because usually one or two of those will solve that problem.
Yeah. It has been, the rash of them have been in the more rural counties of West Tennessee. Not that that's any different. Not that it makes the violation any less or more. But
it actually is.
But that's what I'm saying. So, I don't know. I just wanted to bring that up. Didn't mean to go off on a tangent with it. But anyway, we are close to 2 o'clock here. I know y'all got a meeting over there at 2 o'clock, so I don't want to keep you from that. But certainly great roundtable discussion. Learned a bunch here about QBS. Maybe quite a bit more than what we knew we were bargained for. But certainly great topic of discussion. I want to thank everybody for their time and efforts. I'm sorry your lunch was cut short. But certainly was valuable time.
We got some left over.
Thank you again.
We need to